Thank you. All right, welcome everyone. You are here today for a zoning appeals docket for Tuesday, April 6th, 2021. Just to let everyone know, this is being conducted via WebEx. And before I turn it over to the chair, I want to kind of go over how things are set up on the screen for those of you who have never participated before. There are buttons at the very bottom where you can raise your hand. You can mute and unmute yourself. Right now, everybody, as you came in, you were muted. When your case is called, I will make you a panelist. And if your camera is functional, you can turn your camera on and we will be able to see you. If you would like to testify in support or opposition for a matter, there's two ways to let me know how you wish to testify. You can put a message in the chat feature, and you can also raise your hand. I would ask that no one put anything in the Q&A because that one is difficult for me to track during the meeting. I think there are a few things in the Q&A that I tried to take care of right away, but please do not put anything in the Q&A. If you wish to testify, please raise your hand. Now, as we go through the docket, things might not necessarily be taken in order in the agenda that's published on our website. So please be sure to listen as to hear when your case is called. Testimony goes as follows. The applicant goes first. Any testimony in support will come second. Any testimony in opposition third. And then the applicant gets the last word, and then testimony will close. If you have any issues with WebEx, you can call our office. Someone will be able to answer your call. Our phone number is 410-396-4301. Please do not email me. I will not be monitoring my email during the hearing, so I won't be able to address it. If you are having technical difficulties and can't participate, you can email those issues to me in a motion. Or you can also email them directly to the BMZA email address, which is bmza@baltimorecity.gov. And with that, I will turn it over to the chair to start the meeting.
Thank you, Ms. Byrne. The board will vote on each case and make a decision at the end of the docket. You may feel free to stay on the line or on the video logged in to hear that deliberation. Otherwise, you can call the BMZA office tomorrow morning, 9 a.m. That number is 410-396-4601. I'm sorry, 410-396-4301. Again, 410-396-4301. They receive a resolution in the mail within 30 days. Even with snail mail, which is even slower than it used to be. We ask that you do any work until your resolution is received, and of course, don't do any work in Baltimore City without pulling the proper permits. We have, it looks like a lengthy consent docket, a fewer cases on the general docket, but at least one of them is a pretty lengthy case. And that will be at the end of the docket. We do have two matters that have been withdrawn. They were listed in the written docket, but they've now been withdrawn. Those cases are 2021-005, 3525 West Caton Avenue. The appellant was and is KC Sign Company. And the second one is 2021-006, 1300 North Eden Street. Also, the appellant is also KC Sign Company. Those two matters have been today. They may be rescheduled at a later date. I think I mentioned that. Yes, sir.
Your audio is really broken up.
Ooh, here we go. World of virtual hearings. I'll try to speak up, and then if anybody has any issues, just please let me know, because I want us to be heard. How's this, Bill? Can you hear me?
Yeah, I can hear you. It just breaks up.
Okay.
Go.
Hang on. slight adjustment here. Hopefully that will help. Don't know. Ms. Byrne, I'm going to reference the 2021-007. Or do you want to we'll just call it in the ordinary course? What do you think?
Yeah. Let's go ahead and try to call it now. See if
Okay.
if she's on the line, and if not, we'll just go ahead and mark that withdrawn. As I said, we got a call asking to withdraw it.
Okay, and that is case number 2021-007, 5011 Hamilton Avenue. The appellant is Marshall Renee Jackson, and that was a request for a conditional use approval to use as a daycare center. We understand there's been a request to withdraw that matter and confirm that.
All right. I do not see Miss Jackson in the list of attendees. I'm going to go through the call-in users. So for those of you on the line, if you are a call-in user, I'm going to mute and unmute you. And what you'll hear is 2 beeps. If it's pertaining to the case that you're called for, that you're calling in for, go ahead and speak. If not, you can remain silent.
Beeps. Hello, Charles Maloney for 2020-63.
Okay, that case has not been called yet, sir. All right, so we only had 3 call-in users so far. Ms. Jackson is not, again, in the list, so we'll go ahead and mark that one as withdrawn.
Very well. All right, as I mentioned, we have the consent docket, and consent cases are those cases for which the board has sufficient information to approve the appellant's request. And so I will call those cases, and we'll at least get the appellant, on the line. I'll hear any staff or planning reports, and then we'll resolve the claims with the very briefly. So the first case on the consent docket is case number 2020-117, 4218 Connecticut Avenue. Appellant is
Go ahead.
Appellant is Cheryl Finley, and this is a request for a variance for a 6-foot fence height and corner yard setback. And I'll hear any reports.
Okay, for staff report for BMZA, the variance is to the height of the fence to be 6 feet. It's a corner yard setback, a side yard setback, and a rear yard setback. And Miss Finley is on the line. I will unmute her. Miss Finley?
Yes, can you hear me?
I can. I'm going to elevate you to a panelist, so stay one moment with me. All right, since you're on the phone, I can't make you a panelist, but we can still hear you. The other thing that I needed to add was Ms. Finley submitted a petition that had 11 signatures in support of her variance request to build a fence around her property at the 6-foot height requirement and for the setback requirements. So Ms. Finley, go ahead.
Do we have anything from planning before we hear from Ms. Finley?
Oh, thank you, Mr. Chairman. Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
Very well, thank you, Mr. French. Ms. Finley?
Yes.
Good afternoon. Since we're on the consent docket, the question I have for you is whether or not you'd like to add anything to your application at this time.
No, not at this time. I would just like to thank you guys for taking the time out for hearing this appeal.
Okay, very well. Well, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
Great. Next matter on the consent docket, case number 2020-247, 3310 Gwynns Falls Parkway. The appellant is Jihan Diaz. This is a request for a variance required for bulk and yard regulations to construct a two-story rear addition and a rear deck. And I'll hear from staff and/or planning.
The applicant needs an 18% variance for lot coverage in order to construct the two-story rear addition. There are no letters in support, no letters in opposition.
Planning Department has no comment on this application. Thank you.
All right, and I believe I've got John here on the line. Johan?
Yeah, John.
Is it John?
Yes. I misread an I in the first name, so I apologize. John Diaz.
John?
Yes, I'm here.
Okay, is there any, go ahead.
Yes, I don't have anything to add for the application. I just have to argue that other properties in the same neighborhood that has this kind of and bigger kind of additions, and I just want to thank you too.
Very well, Mr. Diaz. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you very much.
Thank you so much.
All righty. Have a great day. Next matter on the consent docket, case number 2021-008, 500 Sheridan Avenue. The appellant is DJ Real Estate LLC. The purpose of this appeal is a neighborhood commercial. Let's see. It's a request to use a residential premises for an office space. The neighborhood commercial use provision. Now here from staff for planning.
The permit records indicate various neighborhood commercial uses being approved on the site over the last 25 years in the basement and the first floor. The zoning of this particular property prior to transform was B22 in a district where commercial offices were permitted as a matter of right.
And Planning Department has no comment on this application. Thank you.
Thank you. And whom do we have from DJ Real Estate?
Hold on 1 second. Let me see if I can find that individual. Mr. Silverman, I believe.
Yes.
Mr. Silverman?
Yes, good afternoon. How you doing?
Good.
Good afternoon, sir.
I apologize. Go ahead.
No, Mr. Silverman, all I want to know is whether or not you have anything to add to your application at this time, sir.
Just very briefly, myself and Phyllis Gilmore, the president of McCabe, or Woodbourne McCabe Community, executed a resolution with the community support for the use of office space for the 4 units there going forward, and the belief would be beneficial to the community. And as indicated in the past, there have been commercial use up and down York Road with this property, and there were previously approved aspects for that. And the only change would be on that 500 Sheridan unit. If in the future, an agreement between myself and the community, if in the future someone else wanted to use that 1 unit for office space, I would just get the community's approval for that office space use. But otherwise, the community is in full support of the office space use for those units.
Okay. With regard to that agreement, is that something you'd like to submit and have made it part of the record?
Yeah, I can make it part of the record. I can either read it into the record or just email it over.
Well, I think that typically we would take it if we were live and in color, but go ahead and email it over so we can append that to the extent reference is made to it in the final resolution.
Okay, I can certainly. I'll email that. Who should I email that over to?
Ms. Byrne?
That can come over to me. You can send it to Kathleen, KATHLEEN .BY. I think you have my email address.
Yeah, unfortunately, you've had to deal with. Unfortunately, or fortunately for us, your cooperation certainly helped with this process.
All right, happy to be there via email. So go ahead and send me the document. We'll make sure we get it into the record.
All right, I'm sending it right now.
Okay. Well, again, so the board, having heard your appeal, Mr. Silverman, with those additions and then add-ons, we believe we have sufficient information to approve your appeal. So you're good to go.
Thank you so much.
All right, thank you, sir. Have a great day.
Goodbye.
Moving on, the next case on the consent docket is case number 2021-012. The premises is 2418 Ten Oak Road. The appellant is Desmond Stinney, and this involves a variance to required bulk and yard regulations to construct a detached garage in the rear yard. I'll hear from staff indoor planning.
The request is for a height variance of 5 feet. I believe the standard is 15 feet, and the garage's height is they're seeking is 20. So the variance is 5 feet. No letters in support or opposition.
Planning Department has no comment on this application. Thank you.
Very well.
And Desmond Stinney, Mr. Stinney, I've unmuted you. You're the applicant.
Yes, I am.
Good afternoon, Mr. Stinney. Do you have anything you'd like to add to your application at this time, sir?
Well, I just want to note that I did submit 10 letters of support with the application subsequent to the application. I can certainly send those to whoever needs them here, but it doesn't sound like it made it over to you.
It did not. Just by chance, do you know what which address you sent it to?
Yeah, let me just give you the person.
Oh, wait. I apologize. I do have that. I'm so sorry. I do have 10 letters of support. I take that back. I apologize. I'm glad you raised that. But I did get all 10.
Excellent. That's all I would like to add.
Okay, so those have been submitted and will be part of the record for this matter. And that being said, is there anything else you'd like to add to your application at this time, Mr. Stinney?
No, sir.
Very well. Well, the board, having heard your appeal, I believe we have sufficient information to approve your appeal. Thank you, sir.
Appreciate your time. Thanks, everyone.
All right, take care. Final case on the consent docket, and today is case number 2021-013. The address is 414 South Conklin Street. The appellant is Clint Hura, and this involves a variance to required bulk yard regulations to renovate existing building for 8 dwelling units. Now, hear any reports we have from staff or planning.
It's a lot area variance for the MFD. They're seeking a 510 square foot variance out of the required 4,400 square feet. And I did not see any letters in support or opposition with this application.
Planning Department notes this property is located in the Highlandtown Business Area Urban Renewal Plan area. That plan does have design standards and requirements for new construction and for rehabilitation of buildings. This particular building is going to be in a sense, a substantial rehabilitation with an addition on the rear, which is the primary reason for the request for the board's approval. The department therefore requests that the board provide as a condition of approval that the approval be subject to the condition that the proposed additions to the existing structure are completed in accordance with architectural designs and plans approved by the community and the Department of Planning in accordance with that urban renewal plan. Thank you.
All right, thank you, Mr. French.
All right, so Clint Hubra is the applicant with Stony Creek Capital. I do not see Mr. Hubra in here. Is there anybody here for Stony Creek Capital or this particular property? If you could please put a message to me in the chat right now or raise your hand. And Simon, I'm going to ask you to help me as well. Look for raised hands here. All right, let's try the call-in users. If you hear 2 dots and you're here for this particular appeal at 414 South Conkling, please speak. No. All right, so let me see. And please don't put anything in the question and answer because I can't see the question and answer. Hold on, it looks like there might be something in there. All right, I do not see Mr. Hubra in the question and answer. All right, I'll ask Roxana if she can try to get him on the phone to see if something happened here. I don't see anybody else raising their hand for this particular matter. Maybe we can just put this off.
Sure, we'll recall that one before we wrap up the docket.
Okay,
All
sounds
right.
good.
All right. Let's see. All right, we'll begin our regular docket at this time. Going to call 2 matters, 3108 Pressman and 1607 North Hilton Street. But let's go with case number 2021-009. The address is 3108 Pressman Street. The appellant is Derek Shaw. And this request involves a variance to bulk and yard regulations to use as a multifamily dwelling consisting of 3 dwelling units. And I'll hear from staff planning.
Again, this is, as you stated, a request for a variance to lot coverage that basically stating that a multifamily dwelling of 3 DUs exists in an R6. The issue that we have in the research is that no zoning card was able to be located for this particular property showing its last authorized use. The property was not registered nor licensed as a rental property. There was a registration submitted in 2021 for 2 DUs, but no backup documentation. Photos in records of property maintenance records from DHCD show it may have been operated as an MFD since 2009, but we have nothing from the applicant in the application that identifies the property as being used as a multifamily. The board can't actually convert a single family to a multifamily, so the applicant needs to provide evidence that it is a multifamily and has been a multifamily.
Thank you.
Sort of in the same vein, Planning Department reviewed this application, noted that the property, according to one of the records available to the department, was last authorized for use as a multifamily dwelling containing 2 dwelling units. However, it presently has metered electric service for only 1 dwelling unit. And therefore, the applicant is going to need to prove that the multifamily dwelling use was not abandoned or discontinued in order for this application to proceed in front of the board, because in the R6 zoning district, conversion of multifamily dwellings to, single-family dwellings to multifamily dwellings is not authorized by the zoning code. The department is therefore recommending disapproval of the application unless the applicant can document lawful continuous use of the property as a multifamily dwelling unit containing 2 or more dwelling units. If that cannot be established, disapproval would be required because the zoning code does not authorize conversion of a single-family dwelling to a multifamily dwelling in the R6 zoning district where the property is located. If multifamily use is established, the department also recommends disapproval of this application unless the applicant provides the board information establishing that the variances needed for approval comply with standards for approval of a variance specified in subsection 5-308A of the zoning code. Thank you.
Thank you, Mr. French. Guess we'll. Fine.
Yes, I'm here.
Okay.
Hello, everyone. I actually provided photos of the metered services at the unit. I guess it didn't make it to you all.
Yeah, when did you send those photos, sir?
I sent it to the when I filed my original petition with the people on the first floor. I, that office where you got to go when you write everything up. I forgot the gentleman's name, but I provided that when I submitted my application because he asked me to submit it, and I guess the photos didn't make it up. This new process is very convoluted. Beforehand, I could just walk it up to that office and y'all would have it. So now I'm relying on it to come from one office to your office, and I guess it got lost. I can't hear you.
Sorry, I muted myself. Sorry. I think the only thing that we showed in the file, and Mr. French, correct me if I'm wrong, was it showed only one electric meter, not two.
It was 3 meters set up in the photo. It was three. It was one. Yes, one actual meter in, but it was 3 meter cans at the property already.
Okay, we don't have that.
Right. That's what I provided. That's clear because I provided that down to the lower office. And I get, so who do I email that photo to because I have it?
You would need to send it to myself and also to planning.
Okay, no problem.
Yeah, for your information, Mr. Shaw, the photograph that we did see, which may have come up from zoning administration, shows an open cabinet door that would have covered the utility panel for the electricity.
Right.
And it clearly shows that there were at one time mounted as many as 3, possibly 4 electric meters.
Exactly.
4, of course, would have made sense for 3 units because there would have been 3 separate units plus a public service or common area meter.
Yes.
But there's only one actual electric meter in service in the photograph. The other 3 panels do not have electric meters on them. And it's normal, as we understand it, for BG&E to pull meters out of places where a dwelling unit no longer exists.
Well, when I bought the property, Mr. French, the owner assured me that because his mother-in-law used to own it, she always had it operating as 3 units. Currently, it was just one. Yep, that photo. It was just one in there because it was one person residing on the 3rd floor, on the top floor. That the other two meters wasn't filled because no one was living there at that time. But it's always from the previous owners and the neighbors was always set up as 3 units.
So, Mr. Shaw, is this the photograph that you submitted?
That is the one, yes.
Okay. And this is what Mr. French is trying to say, is that it has to be a continually operated MFD. So normally we would see additional information. So if you'd like to go back to the person that you bought it from to get some additional information to submit to us to show the continual operation as 3 units, because this doesn't really do it because it's not functional and we don't know when they were taken out. Do you know what I mean?
Yeah, I do. I certainly do understand what you're saying, but the continued use always been that they just didn't have any tenants living in the other 2 units, so naturally BG&E come and reclaim their equipment as the tenants come and go. So that's why the meter cans remain there at the property.
Well, given at least the understanding that we have of BG&E, if it's not operated as multifamily dwelling, you're right, they will remove those meters, which looks like has been done, and that's what you're confirming. So it sounds like you're confirming the use as something other than a multifamily dwelling.
No, it was a multifamily when they became when the units became the 1 unit was already occupied with one existing tenant. The other 2 units became vacant, but the use was always it was always set up. That's why the meter cans was there for the 3 units. So it's just a continued use application. So that as BG&E came and reclaimed their equipment because no one moved in there because the people were selling the building, naturally me. So that's why I realized that it was never zoned correctly as the 3 unit. It was set up like you were saying, the 2 DU. It should have been set up as the 3 units.
One of the difficulties that we have here is that the zoning card cannot be found, and the parcel record in the electronic file that's maintained by DHCD does not indicate single family or multifamily. So we have no way to provide Mr. Shaw with any record of what existed prior to when he purchased it.
So it's setting up a sort of distinction here, and I think it may be a distinction with a difference here. So, oftentimes, I guess there are multifamily dwellings where you don't have the particular units fully occupied, the building fully occupied, that make it, let's say you have a building with 3 units and you only have one tenant for a substantial period of time. Is that still a multifamily dwelling when there are not multifamilies, in there? And I take it that the person living, and you can confirm this, Mr. Shaw, is the person living there, the single individual living there, the non-owner, is that a tenant?
It's a non-owner, yes. She's been there for over 10 years.
Do you know? I'm sorry. Do you? Go ahead, sir.
It was people residing in there, but as the original owner, from my understanding, deceased because she was living in one unit. So she was living on premises in the unit underneath of the top floor unit. So she was in the middle unit and somebody was underneath of that tenant. But she's now deceased and her daughter's taken, who I bought the property from, bought it from the daughter. But it was always people residing in there up until the passing of the owner.
How long has there been just one tenant in the building, as far as you know?
Well, the owner just died because of COVID. So the owner was living there. I think she died in November, something like that, from what I understand from the daughter. And I bought the property right there shortly thereafter, because I own the property right next to it.
You bought the property in November of 2020?
No. I bought the property in February. We finally did everything. Everything was slowed up because of COVID. We couldn't do closing. So we had a contract pending since December. The mom died in November. The contract was pending since December. We finally went to closing, I think February timeframe. We finally went to closing. But it was always from the tenant that lives upstairs. She said it was always people residing in there. They just decided not to rent the bottom unit out for substantial because they was going to remodel it. Then they ultimately just decided to sell, so they stopped what they was doing.
With the BG, I imagine BGE records would show when those meters were removed.
That would take a court order for me to petition those records.
No, I'm not asking you, frankly, Mr. Just the folks here. I mean, imagine there'd be a record from BG&E as to the date of the removal of those boxes. Do you know, Mr. Ferris?
I mean, there should be. Martin, do you have any thoughts?
My comment would be, yeah, I'm sure BG&E has a record of when they did this. Part of the issue here, of course, was multifamily use ever lawfully established in the first place? Because, as Ms. Burns said, there is no record of any licensure of the property as a multifamily dwelling or registration of it as a multifamily dwelling. And that registration and licensing requirement has been in effect for a number of years. So the previous owner certainly would have had ample opportunity to register and license the property as a multifamily dwelling. And, the issue that Mr. Shaw faces, of course, is why did BG&E pull the meters? Is it possibly because of that issue that previous owner never resolved? I would not know, but it's his burden to show that there was lawful establishment of multifamily use in the first place in order for his application to proceed, because otherwise, he's up against the fact that if the zoning of the property is R6, multifamily dwelling conversion cannot be authorized by anybody.
Understood.
Well, a point of thing Ms. Byrne did mention is that it was the use was 2 dwellings at one point because I registered the properties as two dwellings as part of that, right, Ms. Byrne?
Well, we received a registration in 2021
Right, that's
for 2 dwelling units, and that's something that you submitted. I mean, and and this is normally, Mr. Shaw, I'd be able to go downstairs, look in the card catalog and find the history, and it's not there. We've recently had the card scanned. I sat with the person at DHCD that's responsible for getting those cards scanned. And because I know a little bit about rental licensing, I will tell you that if the property is owner occupied and they have a tenant in it, even if it's 2 DUs, you don't have to license, right? So there's a
Right.
lot of information that could be available, but if, as you say, the prior owner lived there and rented out another unit, they would not have had to be licensed. I looked,
Right.
there's no vacant building notice, right? So that means that even if there was, it wasn't taken back. So I think, Mr. Shaw, it's kind of the ball's in your court to give us as much information as you have to tell the board that it's been a multifamily, because we don't have anything.
Mr. Shaw, I will mention to you that if if there are other sources that you can go to find out this information and you don't have it presently, one, because you may have thought you might not need it, I think the board may be amenable to a postponement request, if you'd like, for the benefit of you to go search out that information that we're seeking. Because we're not in a position to, as Mr. French stated, go forward in the absence of certain critical information that we need, confirm that there's authorization to grant this request. We need those showings to be made. The burden is yours to do so. Right now, we don't see it in the record. But what I think may be the case also is that you have not explored whether or not there may be some other evidence that you can gather to help support that history. So I'll ask you if you'd like to.
Yeah, Mr. Fields, I'll take the postponement request and I'll work back with the daughter, and because that was our childhood home, so no one else better than her would know. But I'll work back with the daughter and then the tenant that now resides on the top floor, to garner some letters of support to substantiate what the use was.
Okay, that would be helpful, and I imagine we can reset it on the docket when it's going to take some time. And you stay in touch with Ms. Burns' office to let them know when you would like this on the docket, so that you're prepared with all the additional evidence that you will gather.
Would like a 30-day postponement be possible, Ms. Burns?
Sure. Up to you. If you need additional time, that's fine too. Just if you want to just reach back out to us, and we'll see if we can get you back on the docket as quickly as we can once you get that information.
Okay, no problem. I'll reach out to you, or Roxana was the person I was communicating with from y'all.
Roxana's better than reaching out to me, because Roxana has the docket, right? She's the scheduling person. So please reach out to her. That's probably your best bet.
Certainly.
All right. Very well. Thank you, Mr. Shaw. We look forward to hearing from you again.
Sure thing.
All right. And moving on to case number 2021-010, 1607 North Hilton Street. The appellant is Vicki Johnson. And this matter also pertains to a variance to bulk and yard regulations for use as a multifamily dwelling consisting of 4 dwelling units. Do we have any staff reports?
Yes.
Planning.
In the research done by staff, the BMZA granted an appeal to convert from a single family to a multifamily, basically 2 dwelling units, in 1991. Searching the property registration and licensing system of DHCD, the property has been licensed as 4 dwelling units since 2018. We were able to obtain inspection reports as well as the licensing history. Looking at the registration for the property, it was identified back in 2009 as 2 dwelling units. And in addition, we were able to find the zoning card for this one. And this zoning card identified 2 dwelling units from 1991. So when the board did the approval they got the use and occupancy for 2 dwelling units based on the zoning card.
Thank you for that information. Mr. French?
Better outcome than the last one, I think. The department had the same questions and concerns as the previous case. Because the property is also zoned R6, conversion of a property from single family to multifamily is not allowed in that zoning district. There was, unfortunately, in records available to the planning department, no indication that multifamily use had been authorized. The property was listed as classified as a single family semi-detached dwelling. So given the information that Ms. Byrne has indicated, the department is going to change its position from recommending disapproval unless the applicant could show lawful continuous use to no objection to approval. Thank you.
Thank you, Mr. French.
The applicant is Vicki Johnson. Let me find Miss Johnson here. And there she is. Miss Johnson.
Hold on. Hello, everyone.
Good afternoon, Ms. Johnson. Thank you for appearing today. We're here on your request to, I guess, to increase the number of dwelling units from 2 to 4.
Yes, I'd like to give some background. If
Sure.
That's okay. Okay.
It's fine.
I bought the property back in 2005 from the owner's widow. At that time, her family was assisting her. They didn't really know much about the property. I think it was sold as is. We went to settlement. There were actually 3 units there. The basement at the time was just had a lot of stuff in it. They didn't live in the property. They had rented the property out, but they were, I guess they used the basement, part of the basement as living space and the other part as storage. So when we went to settlement and we saw the property, I think in the morning, and then by the afternoon we went to settlement, we realized there is also a fully functional basement, apartment in the basement. So I was under the impression that that would be taken care of as far as the occupancy change or upgrades. I'm not sure. It just didn't pan out. I don't have any record of showing anything different than what Ms. Bryant has found. But I lived in the apartment, the first floor, and have been renting out the basements and upstairs since I bought the property. Let's see. I've done all my inspections as far as when MDE came out and we had to do the lead inspection. All the property on all the apartments that I rented were had those inspections. When I moved out in 2014, I rented my apartment out. Nothing changed as far as I didn't realize I had to change the I guess resubmit the occupancy regulations or something, or change the occupancy when I moved out. But I've always did whatever was required of me as far as rental licensing, inspections, MTE, lead inspections, and all that. So I'm not sure. That's where that stands. But you should be able to find all those inspections somewhere.
Yeah, I do believe we have a history. We have the records, evidence in the inspections, as Ms. Byrne indicated. And otherwise, I think the history is sufficient, it appears, to establish the prior use as a multifamily dwelling. And so we don't have those issues where we can't confirm that. I think we're there.
Okay.
But is there anything else you'd like to add to your application that hasn't already been submitted or stated?
Nope, I'm good. Thank you.
Any questions on the board for Ms. Johnson? All right. Okay, Ms. Johnson, thank you for your presentation, and we'll take this up in the deliberation portion of the meeting.
Thank you.
Thank you. Have a good day. All right. Okay, gonna circle back to first case that appeared on our agenda. Case number 2020-063, 5500 Green Spring Avenue. The appellant is Leah Barron, and this matter involves a variance required for a 6-foot fence height and corner yard setback on Rogers Avenue. And I'll hear from staff and or planning.
Okay. Mr. French, did you have anything on this one or no?
No, the planning department has no comment on this application. Thank you very much.
All right. So as you stated, this is a request for a variance to height and to setbacks basically all the way around. So I want to make sure we get all sides of the fence that was requested. We have several letters in support, I think approximately 5 letters in support and 2 letters in opposition. And I believe the owner is represented by Nicole Lacoste Folks. And I will make Miss Folks, I will unmute her, Miss Folks. And I will make her a panelist. Okay, there we go.
Okay, good afternoon, Ms. Folks.
Good afternoon.
Okay, go ahead and proceed. Tell us about this project.
Certainly. First and foremost, thank you, Mr. Chair and the commissioners for hearing this appeal. My name is Nicole Lacoste Folks. I'm the attorney representing the property owners, and that's Leah Barron and her husband, Nicholas Tomasino. They are both on this WebEx as well, and I expect them to speak. So at some point, if you could make them panelists, that would be great.
Sure.
We're talking about their primary residence at 5500 Green Spring Avenue. And it's at the corner of Green Spring and West Rogers. And it's important to note the close proximity of this intersection. It is just 1 block north of Northern Parkway. And at that intersection of Northern Parkway and the Sinai Hospital complex, as well as Pimlico, just a little bit further to the west. So they're in very close proximity to those 2 high-use properties. They purchased this property just a little bit under a year and a half ago. And although when they were looking at the property, they weren't thrilled with the location, obviously, because they have 2 small children, and they were concerned about the safety being that close to those high-use areas. And so when they purchased the property, they were assured by their real estate agent that they would be able to put a fence up. So they bought the property with that assurance. And in fact, they went ahead and hired a fencing company, which also gave the assurance that they could build the fence, which they did. So the fence is there. They received the violation notice and reached out to neighbors. And Ms. Byrne, you said there were 5 letters of support. We submitted 6. You want me to run through the addresses?
Yes.
I have Douglas Austin of 2310 West Rogers Avenue. I have Daniel and Natalie. Am I going too fast?
You are. Hold on one second. As you see me flipping frantically through. All right, I have Mr. Austin. Yes. All right. Well, I'll tell you what I have.
Okay.
Let's do that way. That might be easier. So I have Daniel Mendelson.
And his wife Natalie, correct?
And his wife Natalie. I have Adam Kazan and Frederick Mock.
Correct.
I have John and Arlene Brothers.
Correct.
I have Jillian Babb and Robert Babb. And I have Sarah Rankin.
Correct.
Mr. Austin. That was the one I did not add to my list. And Mr. Austin's letter.
His letter was just provided yesterday. Douglas Austin. Yes.
Yes.
Thank you. Thank you. So they reached out to neighbors and asked, after they got the violation notice, they reached out to neighbors and talked to them, and they got some feedback. And so with the feedback, they have already agreed to spend the money and rebuild that side yard fence. So it would only require a 4-foot variance. So that's what's being asked on that side. Because it's in the required yard area under the zoning code, we are also simultaneously asking for a height variance to allow for the existing 6-foot height at this wooden board-on-board fence with the lattice on top. This fence clearly it meets all the requirements set forth in the zoning code for a variance of this kind. And if it would please the commissioners, I can run through the written document that I submitted outlining how this fence meets all the standards. So I'll proceed with that.
Sure.
As far as the uniqueness standard, this property is unique. When you look at Exhibit A in the justification statement that I submitted to the board last week, you'll see that Green Spring Avenue coming off of Northern Parkway comes at an angle. And when you're driving northbound on Green Spring Avenue in that particular block, you can see without the fence, you can see directly into their backyard. And this fence is all about security for for the appellant's family. And so that's why the fence would be needed there to provide that security, because that intersection is a busy intersection. Green Spring Avenue is a busy road. It's coming right off of Northern Parkway. Very concerned about people being able to see her children playing in the backyard. That is a big concern. So the uniqueness standard, there's no other property in the area that has that high visibility coming northward on Green Spring Avenue right off of Northern Parkway. For the hardship, the appellant did not create this hardship. They did not. As I mentioned, they purchased the property just a little bit over a year ago, hoping to create a safe place for their children to play. And it's at this busy intersection. The back area of the property is level, but the front yard slopes down. And it slopes down into Green Spring Avenue at the corner of West Rogers and Green Spring. And so, we use the example of the children are playing in the backyard and a ball is kicked over a low fence or no fence at all. She does not want to have any of the children and their friends running after a ball going into the intersection of Green Spring and West Rogers. And so they didn't create this, this hardship. Also, too, it's important to note that the house is located pretty much in the center of this lot. So it takes away the potential for a larger backyard. So they're working with the area that's provided because of where the house is located in this lot. If the house was located further towards the front, then they could have provided the adequate space for the backyard that they're looking for. And then it also, with the backyard, if strict compliance with the zoning code would be required, it would severely restrict how the family can use the backyard, how the children can use the backyard for family-oriented uses. And so we're asking for the expanded setbacks to allow for that. And so the purpose of this appeal is not based on any kind of desire to increase the value or income potential of the property. This purpose of the appeal is solely to provide a safe, secure place for her family to play. And she also has some pets. So it's for her pets to play outdoors and to not be seen while they're playing, for all that traffic coming from Sinai Hospital and Pimlico coming, and anyone else coming up Green Spring Avenue, to not be able to see everything. And so they want that security. And so it's definitely not based on any kind of economic reasoning there. And I'll let my clients speak to this, but they're committed to being city residents. And this is one of the reasons they bought this house, thinking they could have this fenced in area for their children. And even though they've only been at that property for just over a year, they're already a major part of the community. I put into the justification statement some of the social and sports activities that they're working on with their children in the area. And so they're definitely here for the long term if they can keep this fence. The variances are not injurious to the use and enjoyment of property in the immediate area, and they don't substantially diminish and impair property values in the neighborhood. If you look at the 6 support letters, several of them talk about how they feel the fence, it's attractive, and it increases the value of the properties in the area. And they like how it looks. Also, too, the fence does not impair any adequate supply of light and air to any adjacent property. It does not create any hazardous traffic conditions, does not increase the danger of fire. It doesn't otherwise endanger the public safety. And the design of the fence is cohesive with the 6-foot board fence on the adjacent property. And this is the property immediately north of 5500 Green Spring Avenue. They have an existing fence that's been there approximately 25 years, and their design is cohesive with the design of their neighboring property to the north. So it looks nice there. The fence is in harmony with the zoning code, and additionally, the fence complies with the guidelines set forth in the city's landscape manual. The fence is, I'm going to quote from the landscape manual, it's constructed of attractive, durable, low maintenance materials compatible with the character of the neighborhood and or the architectural character of adjacent buildings. And it has an unquote there on the landscape manual. And then it has a wood panel thickness measuring of 3/4 of an inch, which is also recommended in the landscape manual. And I'm referring to page 62 of the landscape manual. Moving on to the conditions, the variance that was being requested today is not precluded by or will not adversely impact any urban renewal plan, the city's comprehensive master plan, or any historical and architectural preservation districts. And this property is not located in any urban renewal area, is not located in any federal or local historic districts. And the variance actually supports the goal of the city comprehensive master plan, and that the fence at the location and the height requested provides a safer environment for children and retains city residents. And the variance will not be detrimental to or endanger the public health, safety, or welfare, and be in any way contrary to the public interest for all the reasons stated above. So with that, we respectfully ask for these variances to be approved, but before I conclude, I would ask that Leah Barron and her husband, Nicholas Tomasino, are added as panelists.
Okay, I will get Ms. Barron on.
And they're calling in together, so just.
Oh, are they? Okay, so it's just under Leah Barron then. Okay. Ms. Barron, I'm going to make you a panelist. Okay.
Okay. Thank you. Thank you very much. And thank you everyone for listening to us today. This is not a position that we ever envisioned ourselves being in and never wanted to be in. We obviously, just made a tremendous mistake at the beginning by not getting the proper permit when we built the fence. And Ms. Lacoste folks spoke some about the sequence of events and how that happened. We very much apologize for that, but now we're here to talk about whether or not this fence should be allowed. And I guess we would just echo everything that she said, that we were very much looking for a home that could be our forever home in Baltimore City, and we were thrilled to get this one. And we intend to stay here forever. We're deeply involved in the Mount Washington community and throughout the Baltimore City community. We know that the house is on a prominent location, and we take that seriously. We try very hard to maintain our property because we know of its visibility. You'll see that we have a number of support letters from neighbors who think that the fence, one, is necessary for the safety of our children, as it was discussed because of the grade of Rogers Avenue. Any type of ball, just as one example, that goes over outside the yard will go straight down to Green Spring Avenue. In addition, Rogers Avenue is a thoroughfare between Pimlico to Sinai down to Northern Parkway. So it's not exactly, a residential street. And then obviously she talked about how we're one house in from Sinai Hospital as well. And we're happy to live here, but we do think that a fence greatly increases the security of our children and to some extent our pets as well. And I guess I would just add, she mentioned that our neighbors already have a fence. So our fence is directly in line with theirs. Theirs is also a 6-foot privacy fence. Of our block on Green Spring Avenue, there are 5 homes. Every one of those homes, now including ours, has a 6-foot privacy fence. We are the only house that has a yard on Rogers Avenue. And that's just because the way our house is faced. But I believe there are 14 residential houses on our block of Rogers right now. One is boarded up. One has been under construction for a long time. There's another building that I believe is a group home. Of those 14 residential properties, approximately, or at least 6 have fences in their backyard. So, we're here today in part because we made the mistake about not getting the original permit, but also because we have a neighbor who, is trying to do right by the community, I suppose, but feels strongly that there should be no fences in Mount Washington. But, I think looking at the circumstances as a whole, we think that what we did, we did it in the best interest of our family. We don't think it detracts from the neighbors. We moved here right before COVID. We didn't know our neighbors. We haven't reached out to friends who live, blocks away in Mount Washington. We only asked immediate neighbors. if they wanted to write a letter of support. And these are people that, we haven't even been able to break bread with because we moved in right before COVID. But nonetheless, they felt so strongly that we were doing right by this property and that the fence was required. And that's why they submitted the support letters. So sorry, I went on a little bit, but I'll let my husband if he wants to add anything.
Yes, hello, thank you. As you may be able to tell, my wife is a little, I guess, stressed about the situation, but the only thing I would really add, I think safety of our children, of course, is paramount, but also I would just like to add that we do care about the community and the city as a whole. We've lived here for many years, and we have, in good faith, taken many steps to invest in this property, including the fence. So although, mistakes were made, and regrettably, we do find ourselves in this position, we did, in good faith, attempt to put in a quality fence that was in line with community standards and what was nearby. I think that's about all I have to say.
Thank you.
Thank you.
All right, thank you, folks, for your presentation. Anything else, Ms. folks?
No, that's it for now.
All right, very well. Thank you. And do we have anybody on the line with the opposition or otherwise in support? Ms. Byrne?
Thank goodness Simon's right next door to tell me that I'm muted as I'm continuing to speak. So Ms. Folks, no other testimony in support at this time?
We would like to respond if there's any opposition after they speak.
Sure, you guys will have the last word. So right now, I believe we have 3 callers on for opposition. I will start with, I believe we have Griffith. So you are unmuted.
Yes, thank you very much. Thank you very much. And I beg the panel's patience with me. I'm new to this process. I am actually, now that I've heard what's going on, I'm very much in support of their application. I'm one of the neighbors they haven't met. I generally don't like fences, but the fence that is there is absolutely understandable, and I do not have any opposition to it, and I hope to meet them someday.
Awesome. Thank you, sir, for your presentation. Appreciate it.
Okay, next hand raised is Susan Janowski. Ms. Janowski?
Yes, hi.
Okay, go ahead.
Yes, I just moved back to the neighborhood. I have children and pets, and so does my next door neighbor. And I don't appreciate that the fence is right on the sidewalk. I don't know why they couldn't have had a setback. As the lawyer who's representing the party mentioned, it is it's unusual that that house was built later. I grew up here, so that used to be an empty lot. The people who developed that property had the house in the corner, not facing West Rogers, but facing Greenspring. So what you probably have seen is that their backyard is like everyone else who lives on West Rogers, like the front yard view. So if you walk down the street, there's a 6-foot fence with no holes in it, right up to the sidewalk. So it's like you almost have to shove over a little bit if you are traveling with your kids and pets down to the neighborhood park. And I just think that the fence could be set back, and I believe the fence could be lower. A lot of people have kids and pets, and I sympathize with the position. I have kids too, but having grown up here all my life, the character of this neighborhood used to be covenants that actually did indicate no fences, and it has changed a good deal. There are fences, there are a lot more of them. I don't object to the neighbors behind me who have a low fence that is like a standard picket fence you could see through. They have pets and dogs and little kids. So I just have found the plea that because kids and pets, 6-foot privacy fence. I don't see that those two go hand in hand. And, that's my position. I'm not no fence. I am lower fence, and I believe there should be a setback. And I'm not sure, honey, I'm not sure to be honest, I don't know what covenant would or would not have ever applied to that property. As I do know that when I was a kid, it was an empty lot that I played in, and that property was later developed. So perhaps it is outside of certain zoning things that other houses in this area had. So that's all. Thank you.
Thank you.
Now I'm going to go through the call-in users. Hello, are you here for 2063? Okay, let's go to the next group. Are you here for this particular hearing, 2020-63?
Oh, you're talking to me?
Hello, are you here for 2020-63?
Are you talking to Andrea Pellegrini?
Yes, Mr. Pellegrini, are you here for this this matter?
No, I'm sorry. No, I'm not, ma'am.
Okay. Sir, are you here for 2020-63? Hello? I believe we did have a call-in user. Hello, sir? Who is here for this particular matter? Yeah, I got Mr. Griffith spoke. Ms. Janowski spoke. I thought there was one other caller. No other
Katie,
hands.
did you see the message in the chat to ask for people's first and last names when they speak?
I did. Okay. So I have Susan Janowski, and then okay, Mr. Pellegrini's here for 2021. Chuck Malone was on earlier. Let me see if Mr. Malone is here. I do not see Mr. Malone in the chat. That's from Miss Janowski. I'm going to unmute. Miss Janowski?
Yeah, I heard him at the very beginning. That was that was Mr. Maloney.
Yeah,
he's a next door neighbor. I can't speak for him. I know that he objected, and you might have a letter from him.
He does. There is a letter from him. So what I'm going to do is I'll just read his letter into the record. Thank you. Okay. There were 3 call-in users when we started. Now there's only 2. So Mr. Charles Malone basically objected to the fence, referencing a restrictive covenant that prohibited high fences set back from Rogers, stated it would be found in the deed. He said the restrictive covenants and conditions in the deed from Sidney Watts to his wife, Virginia Brown, dated September 11th, 1905. He stated that these restrictions apply to all properties in the block, and he wanted to say that the barrier destroys the park-like nature of the neighborhood. And he says it will have a deleterious effect on surrounding property values, and he is not in favor. So that was the only other letter. So I guess Ms. Lacoste?
I'm sorry, were you muted? I couldn't hear you.
Yeah,
I
you
was.
did go out.
Did you guys hear anything that I just said? Was I muted that whole time? Oh,
Yeah.
Not the whole time.
I'm so sorry.
That's right. We heard the letter, and then all of a sudden, I think you started to talk to me, and then it muted, of course.
All right, I must have muted myself and did not unmute you. All right, good. So everybody heard the letter. So Ms. Lacoste, the floor is yours.
Thank you. Thank you very much. So there's 3 points I want to touch on here. We saw Mr. Maloney's letter concerning the restrictive covenants. We don't agree with that in any way. My client, when they purchased the property, purchased title insurance policy. There's no reference to this restrictive covenant. I myself personally have looked in the land records almost 100 years back in deeds reading through every single deed, the land records, no reference to any restrictive covenant whatsoever. So we do not agree with his allegations that there is a restrictive covenant pertaining to fences in this matter. My second point is in response to Ms. Janowski's testimony. We just wanted to emphasize the uniqueness of the property. It's difficult to compare this property to other properties, especially on West Rogers Avenue, because you don't have the sloping land going to Green Spring Avenue, and you don't have the direct line of sight driving or walking northward on Green Spring Avenue in regards to being able to see directly into their backyard. This property has that issue where no other property in that area would have that issue with the angled part of Green Spring Avenue, as I showed in Exhibit 1, attached justification statement. And then lastly, I just wanted to ensure that everyone is clear on there are 4 variances being requested here. One is the height variance for that side, the corner yard that faces Rogers Avenue, and we're asking for the height variance to allow a 6-foot fence there. And as I said, it would be moved back. It's not the existing location. It would be moved back further. So we're just requesting a 4-foot variance on that corner side yard. The interior side yard, we're asking for a variance there because it encroaches into the required yards, and it is not, as we already mentioned, the property to the north already has a fence. So the appellant did not build a new fence on that side, but they just connected to it. And so we're asking for that variance. And then we're lastly asking for variance for the rear, on the rear side for the fence there. And as I mentioned in the justification statement and the exhibits that were provided to the board, that fence is slatted. It is not board on board, so it gives it some visibility with the neighbors. So I just want to add those 3 points on. And once again, if I could ask my client, Ms. Barron, and her husband, Mr. Tomasino, if they have any last points to add for the board's consideration.
All right, thank you all. We'll keep it brief this time. I appreciate your indulgence previously with me. But again, I would just emphasize that this is a very unique lot. I appreciate what Ms. Janowski was saying about the character of Mount Washington, but this lot is no way comparable to the homes in the interior of Mount Washington. As Doug Austin put in his support letter, he calls it the gateway to Mount Washington. We're one house in from Sinai. It's a very unique location. And in fact, I do agree with Ms. Janowski that the fence doesn't look great being the number of, it is a few feet back from the sidewalk right now, but we agree it would look better if it was further back. So that's why you'll see in our request that we do have plans to set it back and to put plantings in front of the fence. We think that that's completely reasonable, and it would make, we think that makes sense. So we have agreed with the neighbors that we've spoken with to that. And I think that's pretty much, I guess, what I wanted to raise.
Yes.
Thank you all.
Thank you. And with that, we ask for your approval of these variances.
Thank you so much for your presentation. Very helpful.
Ms. Folks, could you one more time just identify, just so we make sure that we have the record clear, the exact variances that you're asking for?
Absolutely. I'll start again on the corner.
Oh, Nicole, we lost you. Try again. Oh, I think we lost her.
Yeah. You lost her signal completely, huh?
Lost her signal completely. Yeah, she's unmuted, but we lost her signal completely. We'll communicate and make sure that we get exactly, I want to make sure that we have it exactly right for the board. So I will communicate with her. I'll ask Roxana to send her an email so that we can make sure that we have it captured exactly what they're requesting.
Ms. Byrne, if I may, this is
sure.
Yeah, she is texting me. She said she just got disconnected. I'm sure what you said is fine. My only other point is that if you'll see in all of the opposition has only been to the side along Rogers. So I just wanted to bring that up as well. But yeah, I'm sure she will be happy to communicate you with by email. And thank you all.
Thank you. Okay, and I think that concludes that one. Okay, I think we're done with that one. James?
My cursor went haywire and I could not get the mute button. So now we're good. Now we're good. We got a lot of mute issues today. So that concludes 2020-063 5500 Green Spring Avenue. But before I go to the last case, which is 2020-011, I want to recall we had one that we didn't hear from on the consent docket. Now I'm confused.
That was
which one that was.
That was Conkling Avenue, 2021-0130,
Okay.
Clint Hubra. Let me look to
Yeah.
see
Let me try to find this individual.
if we have anybody here for 414 South Conkling. Please Nate. Okay, here we go. Mr. Prettle.
Good afternoon. My apologies for being late. There was a little confusion with the client, but I am here. So thank you for reconsidering this.
No problem, Mr. Prettle. This again involves a variance to required bulk and yard regulations to renovate existing building for 8 dwelling units. I think we heard from staff or planning, but if we need to hear from it again and make the record complete, we'll do that. And then go to you, Mr. Prettle.
Would you like me to start, or are you hearing from staff again?
Go ahead. Just run that back, Ms. Byrne, whatever you have on this, and Mr. French, if you have anything.
Sure. For this one, it was a request for minimum lot area variance to construct a multifamily. They're only asking for 510 square foot variance out of 4,400 square feet, and it's a redevelopment of an 8-unit MFD.
Okay. Planning Department reviewed the application, noted the properties in the Highlandtown business area, urban renewal plan area. This urban renewal plan allows the proposed use, but it also includes requirements and standards for new construction and for rehabilitation of buildings within that area. The applicant is encouraged to continue working with the Community Review Board established in the urban renewal plan and with the Planning Department to prepare approval plans for the proposed addition to the existing structure and for renovation of the facade of the existing structure. On that basis, the department recommends approval of the application be subject to the condition that the proposed additions to the existing structure are completed in accordance with architectural designs and plans approved by the community and the Department of Planning. Thank you.
Thank you, Mr. French. Mr. Prettle, given those statements by Mr. French and planning, is your client agreeable and amenable to those conditions?
Absolutely. And the development team has already been meeting with the Highlandtown Design Review Panel per the urban renewal plan requirements, and will continue to do so.
Okay. And because you're on the consent docket, the only remaining question I have for you, Mr. Prettle, is if there's anything you'd like to add to the application at this time.
Not at this time, Mr. Chairman.
Very well. Thanks for being with us. And the board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Okay. All right. So glad we wrapped that one up, 2021-013. So now we will go to what I believe is the final case on the docket today, number 2021-011, 6040 Harford Road, CMBS Residential LLC, care of Harris Einstein, the appellant. And this request involves conditional use to use the premises as a residential care facility comprising 17 or more residents. Before we start, I know and recognize that we have a lot of opposition to this matter. As we generally state when we have matters with lots of opposition, we're asking that folks not repeat or duplicate testimony. We're well able here, on the board to parse that out, the information that comes in. And so if you were intending to speak, but you realize before doing so that the point you were seeking to make has already been made, feel free to pass on that opportunity this time around. It could be lengthy in any event. We just want to provide that caution that we not duplicate testimony. And with that, I'll hear from staff and planning regarding this matter.
Chair and board members, I'm gonna say this, that when I was in my former position with DHCD, I was involved with the permit application. I did review the issues that are currently before the board for the then zoning and in conjunction with the then zoning administrator. So I'm taking myself out of this. I'm just gonna give you the overview based on the staff report that was prepared by our staff. If there are any in-depth detailed questions that you have regarding staff report and review, we've got Simon Penning on the line, who is assistant counsel here at the board, who can answer any questions that the board may have about BMZA staff reports. But I can tell you that the application came in to use the premises as a residential care facility for 17 or more residents. The history on this particular property was that the principal structure was built in 1971, was used as a convalescent center under the old code. In 2017, there was a prior case before this board. The board approved to utilize the former convalescent nursing home facility for a 38 residential assisted living facility and a 90 client medical adult daycare facility with 21 off-street parking. BMZA approved this use back in 2017, and the prior owner did pull permits to move forward with that construction. We now have a new application to use the premises as a residential care facility for 17 or more residents, and I will refer to Mr. French.
Thank you.
Okay, the Planning Department reviewed the application, noted that the statement of the applicant was to use the property for a 136-bed residential substance abuse treatment facility. The zoning administrator determined that this was equivalent to a residential care facility for 17 or more residents, which is a conditional use that must be approved by ordinance in the C2 zoning district. However, planning also noted that this property was last authorized for use as a 38-resident assisted living facility and a 90-client medical adult daycare facility with 21 off-street parking spaces by the board's approval of its appeal number 2017-195, dated June the 8th of 2017, an approval that was granted pursuant to terms of the previous zoning code. The application for which that approval was granted stated that the assisted living facility would be on the second floor of the existing building, while the medical adult daycare program would be on the first floor of the building. The current application requests approval of a residential care facility for 136 beds. The term assisted living facility did not appear in the previous zoning code, and thus was not defined in it. The term residential care facility is defined as a group care or similar facility for the 24-hour medical or non-medical care of individuals in need of personal services, supervision, or assistance essential to sustain activities of daily living or to protect the individual. The component terms used within that definition are not defined in the zoning code. While the application does not state whether 136 beds would correspond to a specific number of residents, the zoning administrator determined that the number of residents proposed in this application would exceed 16, which is the maximum number allowed in the C2 zoning district as a permitted use, and therefore that the application was for a conditional use. If approval of a 38-resident assisted living facility is determined by the board to constitute prior approval of a residential care facility for 17 or more residents, and if the use has not been discontinued or abandoned because one or more conditions specified in subsection 5-407A, the zoning code, was met, then the board must also determine whether a modification of conditional use approval previously granted, increasing the number of residents from 38 to 136, would be appropriate according to subsection 5-406 of the zoning code. If the board determines that the previously approved use of the property specified in its decision granting approval of appeal number 2017-195 has been discontinued, then the application should be disapproved, as the zoning code specifies that a residential care facility of 17 or more residents must be approved by ordinance in the C2 zoning district. The department notes that the applicant needs to provide information showing the use of the property in accordance with the board's decision on the appeal number 2017-195 was established in accordance with subsection 407A, 5-407A of the zoning code, or alternatively exercised in accordance with subsection 14-104A of the previous zoning code, and has not been discontinued for a continuous period of 2 years or more, as specified in subsection 5-408A, 408, excuse me, of the zoning code, or subsection 14-104B of the previous zoning code. Should the board determine that sufficient information as described above has not been provided, disapproval of the application would be required because the zoning code does not authorize the board to approve a conditional use residential care facility for 17 or more residents. Thank you.
Hey, can you guys hear me?
Yes, Bill.
Yes.
Yeah,
Yes,
I've
we
been
can hear you,
bounced
Bill.
out. I've been bounced out 3 times.
All right, well, just let us know if that occurs again, because we want to make sure everybody hears what's here. I have a question for Mr. French. On your statement just now, I thought I heard, has planning determined that the use has not been discontinued for the period of time that you mentioned?
No, planning has made no such determination. The evidence that would be presented by the applicant is what would have to establish that.
That's what I thought. I just misheard you. Thank you. Okay, I understand we'll have Mr. Williams
Yes.
do the presentation.
Yes, and I just want to remind everybody of the order. The applicant will go first. Anybody testifying in support will go next, then those in opposition. And I believe we have community association members. I'll do a quick summary of what we have as far as letters that the board also has in their packets. We have letters opposing from Moravia Walther Improvement Association, Waltherson Improvement Association, Hamilton Hills Neighborhood Association, Westfield Neighborhood Improvement Association, Councilman Dorsey, Pastor Lee Hudson with St. Luke Lutheran Church, North Harford Road Community Association, 41 letters from individual community members submitted in opposition, and 2 letters submitted in support. We received 4 letters in opposition this morning, plus the 2 letters in support this morning. Those are not in your packet, but we'll make sure that you have those available. And I'm happy to summarize those for the board if they would like, but I'm sure some of those people might be on the line as well. All right, so Mr. Williams. Mr. Williams, I've just made you a panelist and you are unmuted.
Yes, thank you. And is my sound okay for people?
Yes, sir.
Thank you. Can I share the screen as well?
I will pass you the ball. Okay, do you see the ball?
I do, thank you.
All right, there you go. I'm going to mute myself.
Okay. Great. Thank you, and good afternoon, members of the board. This is Justin Williams. I'm joined by my colleague, and I guess he's off camera. I'm not sure you can see my camera with the screen being shared, but Harris Eisenstein, both from Rosewood Martin Greenberg. I'm joined in person by Bilal Ali, who is the president of CMDS's residential programs. And then calling in, who's available to testify as well, is Andre Pellegrini, who's the VP for Finance and Business Development from CMDS. Mr. French gave a good overview of the issues for the board, and this is sort of be long-winded. This is primarily a legal argument, so I'll be walking the board through our case here of the issues. In the introduction here, I'll also go through the history of how residential substance abuse treatment facilities have been treated under the code and why there are ADA and FHA issues. The board is already aware of the opioid epidemic and the city's response, but just to make a complete record, we're going to briefly discuss that, go through the history of the property that the provided, and go through our primary argument here that board approval should not be required based on those factors that Mr. French mentioned, that there was not a discontinuance of the use, and we are extending what was approved in 2017 as the time assisted living facility, and now under the current code is a residential care facility with 17 or more residents. And then in an alternative, we will be requesting the board's approval to change or reestablish the use. So this is the quick background. This was given to you by Ms. Byrne and Mr. French the background of how we got here. Briefly, in 1970, the property was first established for use as a nursing home. In 2017, the board approved the prior owner to use the property as then, among other things, a 38-bed assisted living facility with which under the current code, Transit Baltimore, would be classified as a residential care facility with 17 or more residents. In 2017, that prior owner obtained a building permit and did work under it. 2019, the applicant before you today acquired the property for use as residential substance abuse treatment, but under the zoning codes categories, that is the same use, a residential care facility with 17 or more residents. In 2019, July, the applicant obtained additional building permits and embarked upon renovations to the interior. So today, the request that's here for you primarily is to have a UNO permit issued. We requested a UNO permit to be issued pursuant to the work we performed to the building. And the zoning administrator responded that this use requires approval from the BMZA. The prior use was changed via a BMZA decision in 2017, and the original conditional use has been abandoned. His position is that a new BMZA hearing will be needed to reestablish the use. And that's what we're refuting here. Our main argument is that the zoning administrator respectfully is incorrect. The applicant is not proceeding under the original conditional use, that 1970 nursing home convalescent facility use, but under the 2017 BMZ decision to allow the 38-bed assisted living facility. And briefly, and we'll go through this in more detail. In 2017, the 38-bed residential care facility for 17 or more residents was allowed and approved. This was vested per the issuance of a building permit, which under the zoning code and the board's or the city's practice is considered exercising the use. Issue has been raised about whether or not the prior operator opened the facility, but for purposes of the zoning code, exercising the use occurs when the building permit's issued. Then the applicant came along to propose and use the property as a residential substance abuse treatment facility, which is the same general use, residential care facility, 17 or more residents. And then this is what Mr. French laid out as well. The other issue for the board to consider is that we are going from ostensibly a 38-bed residential care facility to 136 beds, but there's case law and there's prior precedent for the board to consider that this is intensification, not a change, that requires board approval. Intensification can be done by right. Alternatively, we're just going to present evidence for you for the board to consider that we obtained a zoning confirmation letter from Mr. Veal, zoning administrator, confirming the ability to use the property as proposed. The applicant then acquired the property for approximately $1.7 million and obtained building permits that were issued and then proceeded to renovate the space under those building permits, all in reliance on the zoning letter and the city's willingness to issue the permits. So there's a principle of equitable estoppel here. So to recap, I know there's a lot of facts for the board to consider. So to recap, June 2017, the prior owner obtained approval for a 38-bed facility. November 2017, building permit was issued to the prior owner. 2018 November, the applicant obtains a zoning letter saying we can do this use. April 2019, the applicant acquires the property. July 2019, building permit is issued. And today we're seeking the UNO permit to use the premises now that the work has been completed. And then for completeness, as this could be a contentious case, we recognize there could be arguments for courts to review. We are also requesting an alternative that if the board feels that this change or increase from 38 beds to 136 beds is a change that requires board approval, as opposed to an intensification, then we are affirmatively asking the board to approve that change in the conditional use. And then finally, if the zoning administrator is correct here, because this is his reasoning and statement for why he would not issue us a UNO permit. If he's correct, then we are seeking the board's approval to reestablish this use. Before we go into the meat of the case, I just want to address concerns that we've seen on social media and on letters submitted to the board from prior issues. This will not be a outpatient methadone treatment facility. I want to hammer this home and dwell on this for a moment. There was a concern in the community that I believe some people found a agreement to cooperate that the applicant filed with the Behavioral Health Administration with MDH that checked off this outpatient treatment level 1 box, and that led some people in the community to be concerned or accuse the applicant of being not forthcoming about the proposed use. The issue is that this box is checked because when you seek accreditation as from what's called CARF, the Commission on for Rehabilitation Facilities, you need to check the proper box. Comar tells you to check use this grid to check the appropriate box when the application. So the grid they tell you to use per Comar, we're seeking to do residential facility, and they tell you to check the outpatient treatment box. But again, for the board's reference, if the applicant chose to, the healthcare clinic use would be methadone outpatient treatment facility. That's allowed by right. We're not here seeking that approval. That's not the intent of the applicant. The work and the pictures we'll show you for the facility don't align with that. We're here today to seek approval for a residential care facility with 17 or more residents. Another issue that has been raised is that there's going to be people milling about on Hartford Road. Again, this would be a residential facility where patients won't be permitted to leave without supervision, but moreover, there is no front door on Hartford Road. Residents won't be permitted to have vehicles. So to the extent there's any concerns about crowding, which there should not be, because again, this will not be an outpatient facility. It's not what we're seeking approval for. There's additional backing here and support that there's no door, no place for people to congregate, to wait and hang out before or between classes or group sessions. Just briefly on some background of the zoning for residential substance abuse treatment facilities. Sorry, I went too far. The conditional use ordinance process, which applies to these residential substance abuse treatment facilities, has its roots from the 1950s when there was discriminatory practice in the zoning code against persons seeking treatment for alcoholism. And at that time, not unlike today, the city incarcerated rather than treated people suffering from alcohol addiction, and private entities stepped in to provide alternatives to establish recovery homes. In the 60s, the city council approved legislation for that for the first time over this board's predecessor's objections, authorized the council to establish a quote conditional use ordinance for homes for non-bedridden alcoholics and for care and custody of homeless persons. So how does that relate to today? Well, fast forward to 2012, and the Department of Justice and the City Substance Abuse Directorate brought actions against Baltimore City, claiming the zoning code discriminated against individuals receiving treatment for or in residential substance abuse treatment programs. And noting under the ADA and FHA, that the city is prohibited from implementing a zoning scheme that treats disabled individuals differently. Federal District Court Judge Motz ruled that residents in these facilities fulfill the statutory criteria for protection under the ADA and the FHA. So Judge Motz's order led to the current breakdown in uses that we have in our code today, where there's a distinction in residential care facilities with 16 or fewer residents, which are permitted by right, and 17 or more, which require conditional use approval. And this is important from his order. Judge Motz notes the city of Baltimore is prohibited from implementing a zoning scheme that treats disabled and handicapped individuals differently than non-disabled and handicapped individuals. So that has led to nursing homes, assisted living facilities, and residential substance abuse treatment facilities to now be under the umbrella of one zoning use category, which is a residential care facility. This is sort of similar. There's been cases in Baltimore County as well where there were suits about methadone outpatient treatment facilities, and that the zoning code in Baltimore County, or the zoning regulations there, could not treat healthcare clinics differently than methadone outpatient treatment facilities. But again, the applicant's not seeking to provide outpatient methadone treatment here. But again, under the C2 district, it could by right. And this is just for, the board is certainly aware of the issues that the city and really the country are facing with the opioid epidemic. Just in this last year, we are on pace as a city to have more deaths from overdose from opioids than from COVID. This is through 3/4 of the year. Last year was the most recent numbers available from the state, and Baltimore had 685 deaths in overdoses, and we're on pace for 913 when the final numbers will be tallied. This is worth noting, though, that the city's strategy for responding to the epidemic is to increase access to on-demand evidence-based treatment, which includes residential substance abuse treatment facilities. This is also referenced in the city's master plan, where increasing the availability of effective drug treatment will save lives, reduce crime, rebuild families and neighborhoods. You may hear from opposition, from opponents, that there will be issues with crime in the community caused by this use. But again, we know that now accepted, and it's part of the master plan, that increasing ability and access to drug treatment will save lives and reduce crime and rebuild families and healthy neighborhoods. I'll go through this very quickly since Mr. French gave a thorough background on the property information. This is all public data and is pulled from information. Here's the property to orient where it is in the city. And the site here generally fronts on Harford Road and goes there. There's a little, here's a little driveway out to Old Harford Road. But generally, these are the boundaries here. And there was the 1970 case that Ms. Byrne and Mr. French mentioned that established with the Senate, Mayor, and City Council for the establishment of a convalescent nursing home on the premises. There's also intervening cases, permits. And I saw there was some community letters indicating that the use of the property had stopped in the early 2010s. We don't have any information on that. There is a unit permit from 2011 to use premises as a 104-bed nursing home, and then 2013 to continue the use for nursing home. But most relevant to the board's decision today is this resolution that the board approved in 2017 to use the building for a 38-resident assisted living facility and 90 client medical adult daycare facility with 21 off-street parking spaces. You'll note it was approved by consent. No one in the community is opposed. And that's despite the planning staff report noting that there'd be considerable traffic disruption. There'd be a need for staff to direct vehicles for the daycare center, adult daycare facility. And there'd be interfering with traffic flow on both Harford and Old Harford roads at the times of heaviest traffic demand. But more importantly for the board's legal decision here is that the planning staff report notes that the use, which was at the time a 38-bed assisted living facility, would be a licensed residential care facility with 17 or more persons. Also note that this used for discontinuation or abandonment. The resolution, like all boards' resolutions, parrot the language in the zoning code that you have 1 year to obtain either a building or use and occupancy permit from DHCD within 1 year of the date of the approval. The prior owner obtained that building permit in November 20th, 2017. So only a few months after the June 8th, 2017 approval. So the building permit was issued to do the work. And moreover, the Board of Public Works issued a grant to the prior owner for $250,000 to do some work to the premises. And here it notes that the prior owner renovated, acquired, and equipped to use the premises as, among other things, an assisted living facility. So again, just to recap, reorient you, and this is most important for the board to consider, June 2017, BMZA approval, November 2017, building permit issued, and then 2017-18 work was performed. So the applicant comes along, starting in November 2018, we obtained a zoning confirmation letter that the use is considered now a residential care facility that may be continued. The applicant acquires the property for $1.7 million in April 2019. In July 2019, a building permit is issued to the applicant to perform interior alteration, which is transition from assisted living facility to rooms that are residential substance abuse treatment. Is that my echo?
Could be my dog barking, so go ahead.
Sorry.
Sorry about that.
Don't worry.
We wouldn't get for a muzzle right now, so.
Notice that this is the building permit that was issued, and note, as part of the permit application process, the use proposed was noted on what was signed off on by the zoning office when they approved permits. There was no, there was, I guess, an accusation, allegation that the applicant was hiding the ball or trying to slip under the radar, but the applicant had always been forthcoming about the proposed use of the premises. And then just to fast forward to November 2020, that's when we were informed, the applicant was, that the use requires approval from the BMZA. So that's the background. And so this is where we get into the legal argument. And again, what we're requesting the board to do is determine that as a matter of law, the zoning administrator is incorrect and that a UNO permit should be issued or signed off on, and provided the inspections are passed for the premises, the UNO permit would be issued. So just procedurally, what you consider, you'd be sitting as a traditional appeal from what the zoning administrator did. You would be exercising your powers of review, and we would ask you to reverse the zoning administrator's decision and then exercise the power to sign off on the UNO permit for the premises. So again, just to reorient you to the timeline here, June 2017, BMZA approval, June 2017, transform Baltimore became effective, which made the use a residential care facility. November 2017, the prior owner got a building permit issued. The applicant acquires the property for $1.7 million in April 2019. They obtained another building permit in 2019. Today, we're seeking the UNO permit be issued. So I guess the question is for the board, considering that the issues that I guess perhaps the community may raise is that, can you proceed under the 2017 zoning case? And here's why you can, or why the applicant is able to. The approval was for 38-bed assisted living facility. This was vested pursuant to the issuance of a building permit within 1 year, which is the requirement on the resolution and the zoning code. Where you see in the bright red letters in every resolution that you have 1 year to get a building permit issued. And moreover, work was performed under that permit. This is proven by the Board of Public Works document. And this is notable because there's case law here that even just issuing a permit is exercising the use. So there could be a claim that the prior owner didn't open the facility, but that's not under the zoning codes rules and the case law what's needed to be quote unquote exercising the use. So for example, in Tiazir Viriyim, there was an issue about the closing of a restaurant for 12 months because it was a non-conforming use. And the issue there was, or the allegation was, the restaurant was closed for 12 months and therefore there was an abandonment or discontinuation. In that case, the board found that because the permits were applied for, and the board found this, and then the Court of Special Appeals affirmed, the permits were applied for, the use was sufficiently active. So by comparison, at 6040 Hartford Road, a building permit was actually issued following the board's appeal in 2017-198. In this case, just filing 2 permit applications was sufficient to consider exercising the use. And this is notable also because a vested property right was created. I pulled here this case from Baltimore County talking about the rules for vesting, and just to orient you and consider the issues here. When there's a vested approval in 2017, anything that happened prior to 2017 can't be brought up and raised or as like a concern that would inhibit the future use of the property. So there may be claims or allegations that there was a stoppage of the use in early 2000s or 2010 of the nursing home use, and therefore the nursing home use was abandoned, and that maybe the 2017 case shouldn't have been approved. Ultimately, it was approved by the board and vested pursuant to a building permit. And the importance of vesting, the importance of vesting is key because the time to appeal the decision would have been 2017 when the board approved the use. At the time, it was a 38-bed assisted living facility. And this is important to hammer home. There's a vested property right here because the real estate development process depends on this vesting process and the termination of appeals. If one could look back 10, 20, 100 years to an issue that might have happened previously that would disturb a current approved and issued permit, the whole process for development would fall apart because lenders, construction teams, title companies depend on the finality of the appeals process to make their decisions in lending money. So again, at this point, in November 2017, a building permit was issued, which vests the right to use the property as a residential care facility with 17 or more residents. So the next question for the board to consider is, we have this vested right for 38 beds as a residential care facility. Can it be intensified from 38 to 136? Now, as Mr. French noted, the use category is residential care facility, 17 or more patients. Whether it's 38 beds, 136 beds as proposed here, or 250 beds, they're categorized the same. Residential care facility, 17 or more patients. There was no limit in the number of residents in the order or the initial ordinance. So the initial ordinance in 1970 authorized the nursing home use in the property. There's no limit on the number of people that could be there. And this is a comparison because sometimes ordinances do that. And so if that were the case here, that would be an issue that would need to be, I guess, amended by ordinance at 6040, but we don't have that issue here. But in some cases, for example, Council Bill 09-386, there was an amendment to the maximum number of resident clients. Another bill, 07768, where there was a maximum number of residents codified in the ordinance. Again, there's no limit here in the prior ordinance or in the prior order in 2017. There's also no minimum lot area requirement. So if there were a limit, it might be a typo and oversight, but there's no minimum lot area for a residential care facility. If it were a multifamily dwelling, you use the same provision. So for a C2, we believe there would be upwards of 220 dwelling units permitted on the 50,000 square foot property. Again, we're seeking 136 beds. So there's no limitation under the zoning code for minimum lot area and no limitation under prior approvals or the ordinance that will limit the number of beds on the property. And this is, I think, very compelling. Under case law and city practice, the increase in beds from 38 to 136 has always been treated as intensification and not a change. If it were a change, it would be subject to the provisions of 2203J, where it would be subject to the procedures and requirements imposed by the Code of Conditional Uses. But again, that's not how the board and the city has treated these issues for intensification. And there's a case on this, which is instructive, Cochrane versus Mayor and City Council of Baltimore in 2002. It goes back to 1996 when AT&T obtained conditional use approval to use or erect a rooftop telecommunications facility at the Belvedere Towers. There, no one appealed. And then 4 years later, AT&T determined that it needed to improve capacity for their rooftop equipment. It went back to the board or the city for approval, and which it received. And there, a resident objected and appealed, but the court held the increased capacity was in the nature of an intensification, and that a hearing was not required. So there, in 2000, AT&T had a conditional use approval for rooftop equipment or rooftop telecommunications equipment. It increased the capacity there, and the Court of Special Appeals held you don't need a hearing when you intensify a conditional use. This is also the city's practice. More recently, M&T Bank Stadium had expansion work completed. In the C5 zoning district, stadiums are conditional use. In 2019, the Ravens completed a $120 million renovation that included increased suite areas, and notably in the corner notches. The board members are Ravens fans, you'll be aware of the corner end zone suites that have been newly created, and the I guess it's the Bud Light suite for fans to enjoy in the end zone. But this was an increase in the people that could be in the stadium. But this increased capacity did not trigger the need for BMCA approval. And again, a UNO permit was issued for these new suites without BMCA approval. I have more case law here, and I won't bore the court by going through it all in depth, but there's lots of case law to support that intensifications are allowed and they're not considered changes. So there's a lot of this is the same as the non-conforming uses, where the zoning code says a non-conforming use may not be expanded or any structure erected or expanded unless it conforms to the rules. And this comes up a lot in cases where the owner of a non-conforming use tries to intensify it. Courts have consistently held intensifications are allowed. And a more recent case in 2006 involved the club choices. Some of the more elder Baltimoreans may be familiar or maybe remember the Club Choices Club on North Charles Street. There, it became a non-conforming use when the city implemented its adult entertainment ordinance. And the board at the time restricted the days per week that the club could provide adult entertainment to 2 per week, because that was how often they used the use for adult entertainment prior to it becoming a non-conforming use. The Court of Appeals, with Chief Judge Bell's opinion, noted the frequency of the nights could be intensified, permitted, and would not run afoul of the non-conforming use issues. And his opinion is instructive, and I guess if it becomes an issue that the board would like more information on, I can send the full order on that. Provided this entire PowerPoint presentation to the board staff to be accepted as an exhibit. But there's many examples that are cited in that Tripp Associates, the Marion City Council case by Chief Judge Bell. Notably here, for example, Jonathan v. Staley, while physical expansions of marina property would be prohibited, the intensification of the number of boats would be permitted. So this is an example. This is like our site at 6040 Hartford Road. There's no exterior expansions of the building. It's the same building footprint that's been there for nearly 50 years. We are merely adding more residents to the building. This is like adding more rowboats to the marina. Similarly, the Feldstein v. LaVale zoning board. The issue there was about a non-conforming junkyard, where the board or the court agreed that changes in the quantity and height of the stored scrap metal were an intensification, not an extension of the non-conforming use. Similarly here, an increase in the quantity of residents in the building is an intensification and not an increase. And Green v. Garrett is a good fun case with Baltimore roots when the former Municipal Stadium on 33rd Street, the predecessor Memorial Stadium, at the time was only used for the occasional football game, City College games, Army Navy games, football, and the infrequent baseball game. But when the Oriole Park burned down, the Orioles moved to this stadium. And then at that time, it was a non-conforming use. It had lights, speakers. It had baseball games much more frequently. But the court there held that the extra games was intensification. So by comparison here at 6040, the additional residents were similarly an intensification of the use. So we'd ask the board to consider that at M&T Bank Stadium, and here, one of the cases, the principle that was established there applies here. There are no external changes to the building proposed, respecting the building footprint. If the intensive, and there are no parking issues either. The applicant will not permit residents to have vehicles. They only anticipate having 20 residents on peak shift. Sorry, 20 staff on peak shift. But the 21 spaces on the property could, for zoning code purposes, accommodate up to 84 employees on peak shift. But again, we only anticipate 20 employees to be on site on a peak shift. So in summary, for this legal argument, which is our primary argument, the board should be exercising its powers to review the zoning administrator's decision. We are proceeding under the 2017 case. There was no discontinuance or abandonment, and the use can be intensified. The original use, June 2017, it became vested by Transform Baltimore, issuance of the building permit, and intensification is allowed by right, we argue. So that's our primary legal argument. Our second legal argument, just to put it in front of the board, is that the principle of equitable estoppel should apply here as well. And this is a timeline just to recap. And the applicant in 2018 obtained a zoning confirmation letter. At that time, it was for a 104-bed facility. That was what the letter requested. The applicant acquired the property based on the zoning letter, $1.7 million. A building permit was also issued, and the applicant expended roughly $2.5 million in soft costs and costs to perform the renovations. And so today, the applicant should be stopped from requiring a hearing. I note here, this is the building permit application of reward. Here, zoning signed off on a building permit that was issued. There are on similar facts, the Court of Appeals ruled that Montgomery County was stopped from relying on a changed interpretation. And I have the summary of the case here below from another case, but it summarizes it well, where the court concluded that the long-standing interpretation of the ordinance was reasonable and debatable. I guess to back it up, the applicant in this Montgomery County case relied upon a county official to say the building could be built at a certain height based on how they interpreted the rules at the time. Later, the County Board of Appeals determined that interpretation was wrong, but the court concluded that because it was reasonable and debatable, and there was no oversight of the county, but rather it was consistent practice, the builder had expended substantial funds, the county was stopped to deny the validity of its action. So in similar facts here, it is reasonable and debatable that the 104-bed residential care facility would be permitted in light of the receipt of the zoning confirmation letter and building permit applications that show the proposed use and plans, and that has been permitted. It's been the city's practice to accept an intensification and continuation of a use based on building permits. To change it here would be a change that would be reasonable, though, because the applicant's reliance on the city determination was reasonable. They expended roughly $4.2 million in all in on acquiring property and performing work to make the improvements, and therefore the board should be, or the city should be stopped from arguing that the approval can't be issued. Knock on the door. Sorry, our applicant had to use the restroom. So, as an overview, again, for the board, so we have two arguments here. The primary arguments are that we are disputing the zoning administrator's determination that we are not proceeding under the original conditional use. Again, we're proceeding under the 2017 case, and the intensification is allowed by right. Alternatively, equitable estoppel should apply. So that's our primary legal argument. For completeness, and for the boards, I guess normally this sort of normal court hearing, we would ask the judge to rule on this legal argument before going into the facts, but the normal practice is to proceed. So we'll proceed just to cover our bases with our request that in the event the board finds that the change in beds from 38 to 136 requires the board's approval, then we are asking affirmatively for the board to approve this change in the conditional use. And sort of in the alternative, if the board finds that the zoning administrator is correct and that we're proceeding under the original use, which has been abandoned, we are seeking a new BMCA hearing to reestablish the use as a residential care facility with 136 beds. This is more of a traditional conditional use case, so I won't belabor these points for the board. That that the test for conditional use approval comes from Schultz v. Pritz, or any adverse effects, or where the conditional use application should be approved unless the proposed use at the proposed location would have any adverse effects above and beyond those inherently associated with such a special exception use. Now, as a reminder to the board, as you mentioned earlier, that the residents here are covered by the ADA and the FHA. If people are engaged in illegal drug use, they can be exempt from protection. But here, people and individuals participating in a supervised rehabilitation program and no longer using drugs are protected. Now we know, again, there's already precedent in 2017 when the board approved what was then an assisted living facility as a conditional use, and now under the current code would be a residential care facility. while it's not a binding precedent, if there's a denial here, it would have to be upon issues other than type of treatment the residents will be receiving at this facility. And just note again, for the record, in case there would be issues with traffic at this facility, again, despite the fact that no residents will have vehicles in 2017, the planning staff report noted there could be traffic interference during pickup and drop off at the adult daycare use that was proposed at the time. And one, excuse me, for the board's also reference, there is a significant use test, a significant risk test that would be applied if you wanted to treat the residents here differently. And there's good case law here. It notes about the risk that unsupported fears and stereotypes can come into play in zoning decisions related to, among other things, resident substance abuse facilities. The Supreme Court noted the significant risk test requires an individualized assessment of the facts to achieve the goal of protecting handicapped individuals from deprivations based on prejudice, stereotypes, or unfounded fear, while giving appropriate weight to such legitimate concerns and avoiding exposing others to significant health and safety risks. They cite a case in this opinion where few aspects of a handicap give rise to the same level of public fear and misapprehension as the challenges facing recovering drug addicts. Note, and this is continuing from the court's opinion in the 2012 case citing Supreme Court precedent, when applying the significant risk test, the evidence must be objective and show a significant risk. It must also demonstrate that the risk is one of substantial harm. So here, there may be community concerns. You may hear objections about there being a school nearby, or that residents will be out at the church nearby unsupervised. But again, these are not super predators or even violent criminals who would be out there snatching children up on the way to school or even attempting to sell drugs. These are regular people that are suffering from substance use disorder. While it might not be Nana at the assisted living facility, these are our neighbors at the facility and who will be here. I want to just put on for the board, and I guess for the completeness, some testimony from the president of the residential program at the site, Bilal Ali. Are you swearing anyone in under the current practice?
We have not necessarily been swearing one in individually. It is, but Mr. Ali, I presume you're going to tell the truth, the whole truth, and nothing but the truth as you testify?
Yes, I do, ma'am.
Thank you.
Mm-hmm.
Yeah, Mr. Williams, we haven't formalized that process, but I believe that the position the board is taking, that to the extent any witness is seeking to testify, that they are doing so with the understanding that they're proceeding growth as if you were sworn. Thank you.
Thank you. So, Mr. Ali, could you just tell, and I don't know if you can see him on camera. Well, maybe you can see him on the side. Mr. Ali, can you tell the board your name and address, occupation?
Yes. My name is Bilal Ali. My occupation is I'm a licensed clinical professional counselor and a licensed clinical alcohol and drug clinician.
And then how long have you been the president of residential programs at CMDS?
I accepted this position October the 1st, 2019, coming up on a little less than 2 years.
And can you just talk the board through your relevant history in this field?
Well, I have over 20 years working in various capacities, from supervisors to program supervisors, outpatient, inpatient facility, and just a wide array of positions within the, I would say, recovery community. That's how I like to use the appropriate language in the community.
And you're also on the state legislature, is that correct?
Yeah, yes, I was a former member of the House of Delegates. I was appointed by Governor Hogan in 2017.
Okay, so based on your experience from the policy side and as in the drug treatment side, can you talk about why residential substance abuse treatment is an important modality?
Well, one of the things that we have found through empirical data that residential programs have better outcomes than outpatient facilities. One of the things it allows a patient to do is to be uprooted from that environment and put in sort of a protective environment where there's no drugs, no opportunities for drug seeking and et cetera. And therefore, you have a better opportunity to give the proper therapeutic intervention that that patient would need to alter or modify his maladaptive behavior.
And so the opponents may argue we don't, quote unquote, need this facility here. But in your experience, is there a need for more residential treatment capacity in Baltimore?
I think that's an understatement. As you had mentioned earlier, we harp on the homicides in Baltimore City, which we know for the last 6 years has been 300 plus. But if you look at the data on overdose drugs or any of that related or any of that activity or behavior that's associated with that whole culture contributes to this factor. So when a person, and we treat a person with an addiction as a disease, and that's the model that we use. We use a disease model. So if a person is seeking treatment, which we have basically the numbers that I looked at, that we have over 60,000 active addicts in Baltimore City. And to couple that with an opioid epidemic, I think that it begs the question of what are we going to do with these people if we don't open up facilities to give them access? And as the attorney had mentioned, it's in the master plan. Everybody knows that treatment reduces criminal activity and it reunites family, and it's just the appropriate way to go. And I understand the stigmas and fears that people have about putting a facility in our community. I live in close proximity myself of a treatment facility. But personally, on a personal note, I seen my father die from alcoholism. So that's what I went to school for, to try to help people make these adjustments, make these modifications in their life so they wouldn't have to continue. You know, and it's very rewarding to see people who have went through treatment or have recovered, to see them gainfully employed, they're not using, they're back with their families, their parental oversight for the kids are good. And I understand these stigmas. I mean, just like we had stigmas about mental retardation. Put them in a building somewhere out Spring Grove or Crownsville or Sykesville or any of the mental institutions and just forget about people. But we can't do that today. We don't have that luxury to isolate people and not provide treatment for people who actually want it.
So that segues into can you talk to the board about how at CMDS you will be helping people? What's your philosophy in the residential program?
Well, the treatment modality will be a therapeutic community. And a therapeutic community is a participatory, group-based approach to long-term mental illness, personality disorders, and drug addiction. This approach is usually used in residential programs. Psychotherapy, as well as practical activities, cognitive behavior, life skills, anger management, relapse prevention. The effectiveness is that intervention model for using using this particular modality is with co-occurrent mental health disorders, and the TC helps reduce drug use and subsequent criminal activity. And I think those are some of the main goals. And the TC has a recovery orientation. It focuses on the whole person, the overall lifestyle changes, not simply absence from drugs. And so recovery is seen as a gradual, ongoing process of cognitive change through clinical interventions, and we expect that it take time for program participants to advance through the stages of treatment. And I have a light overview of the stages of treatment here. Basically, we would say stage one or phase one is basically where everyone who comes into the residential facility will get a complete medical assessment. And we know that a lot of our patients come with somatic issues besides the substance abuse disorder. And we have a blackout period that we implement, which doesn't allow the patient to have any interaction with the outside world. And that includes family, no visitors, and et cetera, until that person has progressed along the line. In phase two, there's clinical intervention, one-on-one counseling, group counseling. These are some of the therapeutic intervention process. And phase three is more life skills development, relapse prevention, and stage four is reentry, connecting to the community resource, jobs, vocational training, education, and assessing whatever skill deficit that they may have. We have a number of MOUs with organizations that will accept our patients in Vehicle for Change, the Towson Rehabilitation Center, which focus on diesel mechanics, auto mechanics, things that patients can really make a life living wage, or living wage, I should say.
So residents here will go through all phases 1 through 4 at this facility?
Yes, yes.
And then, but this is not a halfway, people won't be going back and forth. Once they're done with the treatment, they won't be living at the site. Right?
No, they won't be living at the site. That's just the reentry phase sort of helps them adjust to life after residential treatment. So you just can't put people out and not help them make the necessary adjustments that they need to be successful.
Can you talk to the board about day-to-day operation, maybe with the eye towards what's going on in the exterior? Like what's the experience for residents of the facility day-to-day? What's going to happen? Like how many staff will be there?
Well, usually, as you had referenced, in peak hours, it'll be approximately 20 staff. On the night shifts and weekends, you would have a little less staff because we don't have a rigorous clinical schedule. And basically, the clinical schedule, and this is just a basic overview. All patients will wake up in the morning to prepare for breakfast, take care of the personal hygienes and things of that nature. 9 a.m., I would say, not 9 a.m., 7:30 to 9 is when the patients would be fed. We have to make adjustments in the clinical schedule based upon some disruption in the kitchen operations, then we make those adjustments because everybody will get fed. Around 9:30, they have their group morning meeting. That may be a didactic lecture centered around anger management or relapse prevention. That will go approximately 90 minutes. That will segue into getting prepared for your lunch meal. And afternoon, clients would have what we call a fresh air break. Now, we do allow the clients to smoke, but it's not something that we encourage because we also do a nicotine assessment or cessation program to try to get them to. But knowing that you have to prioritize what issue that's the main issue that brought that person or the presenting issue is making sure that we address that, and that is the substance abuse disorder. In the afternoon, there's another didactic group presentation that deals with refusal skills, learning how to say no, because most of these patients are going to go back to the same community. So they have to learn certain skills of how to say no. Now, I know Nancy Reagan made that popular back in the day, but you actually have to learn refusal skills, understand triggers that may precipitate a relapse. And so we look at the recovery process. When you have a lapse, that's an opportunity to teach the patient what was that trigger? Was it, because most people look at relapse and the end result in terms of the person using again. But if the patient is taught the psychological relapse, when that person started getting obsessed with, oh man, this Hennessy was really good, you know what I mean? I'd like to have a Budweiser or etc. That's a mental relapse. So if you teach the patient skills to disrupt those distorted thoughts, then you can keep that person on a track. The physical using of the drug is the last stage of the relapse process. And so basically after dinner, there's another group meeting, which we have AA and NA meetings, but these are closed meetings. This is not an open meeting where people from the outside will come to the facility to participate. This is internally dealing with the patients that are there.
So basically, we've heard just the fresh air break is the only time people will be outside, and that's supervised, right?
Yes, all activities throughout the facility, whether a patient have a choice to go outside, as you can see from the slides on the screen, that we have a full fitness center because we just don't want to focus on one aspect. It's a holistic approach. They can play ping pong, they can use the weights, the treadmill, etc., or they can go to our luxurious lounge in the area to watch TV, etc.
I guess I'm gonna hammer home too, like, so there's supervision during the fresh air break, and then are there any other security precautions that would help keep the board and the community comfortable that people won't be leaving the facility?
I think we went beyond in terms of security. Every window in the facility has an alarm that alerts staff if there have been any breach. We have approximately anywhere 20 surveillance cameras that are monitored by a staff. So if anyone was to try to leave, breach a window to try to get out, staff would automatically be notified. But we have to be mindful that this is not a prison. So we can't physically restrain someone if somebody decides that they want to leave. But if we do have a fiduciary responsibility to report that to whether it's a parole and probation officer, to the court, or etc., and issue monthly progress reports if, in fact, they are sent there by the court.
So you mentioned these photos on the screen for the board, and so in your experience, decades in the drug treatment field, how does this facility compare to other ones?
I'm going to be totally honest with you, and you can go to any facility, and I work for the largest treatment provider or residential treatment provider is Gardenia. They have nothing compared, and I've worked with Gardenia anywhere from 7 to 10 years. So they, by comparison, when Gardenia first started at 4615 Park Heights Avenue, they did the same exact model. They bought a nursing home, they renovated it, and they didn't have the luxury of a fitness center, ping pong, new hygienic facilities, the dining room. I mean, this is just, I think environment is a major contributor to that person, how you're seeing me. If you're in some rundown place that's not up to par, then that patient sort of internalized and sort of value themselves the same way. So we're trying to run a very quality facility that's really going to help people. And that's what I'm in the business of, helping people.
So just for the board's reference, these are the floor plans that show the improvements to the interior.
Mr. Williams, can I ask you a question?
Go for it.
I just wanted to, while you're on the issue, or before you leave the issue of security and staffing, can you describe, Mr. Ali, what the level of security, if any, will be on site during the day and in the evening?
Well, let me give you the COMAR regulations because that makes you in compliance. It's usually 15 to 1. That means for every 15 patients you have to have a staff to address that person, whether it's clinical or otherwise. So we will actually, when on our peak shift, not only will we have counselors, but we have administrators and house managers who perform certain ancillary activities to support the therapeutic community.
Okay, will you have any security personnel on site at all?
When you say
security, somebody whose sole job is to handle security as opposed to therapeutic services.
Yes, the house managers are specifically there to oversee that process. Well, see, when you say security, we have to be careful about language. This is not a prison. This is a facility where people who are seeking help are getting help. When you say security, that may be interpreted that we're running a prison. We're not
I'm being specific about the language. That's why I'm asking. I want to know if you have it or not. And when I say security, I mean solely security.
Okay, and the answer to your question is yes, our house managers perform those security responsibilities.
And
okay.
This video, the conflict resolution.
Absolutely.
I also
question. No armed security. Is that your question, Mr. Chairman?
Sure. Basically, yeah. But what I also would like to know is, I don't recall. I may have rushed through or not seen a slide with regard to the outside. Is the rear or the outside or the back where I imagine the patients obviously will have time outside at some point?
Mm-hmm.
Is that a fenced area? And a locked fence area? Out back behind it that we can't see.
There has been a new privacy fence placed all the way in the back. That may not show up on Google Map, but that has been installed there.
So is that where my laser pointer is showing
yes.
there?
Mm-hmm.
I guess in
yeah.
here. I guess between here and the neighbors.
Because you do have, yeah, you do have residents on the other side of the privacy.
There appears to be a fence here as well.
Yes, yep, along that wall, all the way to an L shape.
Okay, is there a lock on that fence, or is it, free to open and close?
The gate that leads out to Old Hartford Road has a lock on it, and that's only used in event that there's a delivery of food and etc. that they can't get through the side of the building that leads from Hartford Road to the side entrance where the kitchen is at.
Okay, thank you. Sorry to interrupt.
No, that's fine. If you have any questions, jump right in there.
I guess along those lines, as far as the community impact, actually, here's all the static. I saw the Q&A. So maybe it's the dog again. Can you confirm for the board that there won't be no outpatient methadone substance abuse treatment?
Yes, we will definitely, we're here before the board today, and I think that's where a lot of the misinformation, I think that's where a lot of the community opposition, I did extensive community outreach with the school that was mentioned.
Can I just jump in real quick, James? I think we're getting feedback from your mic. So if you could mute, the reporter has asked me because she's getting a lot of feedback. Thank you.
Thank you. Yeah.
Oh, okay.
The one time my dog wasn't barking, I get the feedback. Okay, gotcha.
So, can you hear me?
Yeah.
Okay. So with the community outreach, there was some misconceptions about what type of facility this would be. And so I reached out to the principal, the vice principal, and the president of the PTA. And after I assured them that this is not a methadone program, and that this will be an inpatient facility, and I asked them, how can I work with you? And so I said, what is some of the school's needs? I said that I would offer some of our licensed clinicians doing drug prevention month or week to have counselors come and talk to these kids. We partnered with the school and we gave them over 200 backpacks of school supplies because a lot of these kids have some challenges. And quite frankly, some of the parents, and we offered, if you have any parents that need our service, we will give those parents a preference in that community.
I guess on the topic of community, so I mean, we've heard from Ms. Byrne, many opponents on the line, but there is support, the people you talk to, like this letter, for example.
Oh yes, I've spoken to various residents, but it seems to be a divide between the white residents and the Afro-American residents. And I guess that's just a reality of how people see or what lens they're looking at people that will be part of this facility. I will venture to say that the majority of the residents will be Afro-American. If you're in a majority Afro-American city, then you can reasonably reason that the majority of the people were there. And so Miss Nicole Taylor, who is a licensed social worker by trade, works with kids and lives right around the corner from the facility. She lives in the community and she sent a letter of support. We have another facility in Southwest Baltimore that the president of Franklin Square Community Association, where we had also a community meeting. We had a mixed balance of racial and ethnicity, and they are supportive of residential facility, and we're in the process of opening that facility up. Now, given that that program is not as large as 6040 Harford Road, but it's still the idea that they understand and they're sensitive to people who are seeking this type of treatment.
And so, I mean, in your experience as a legislator and in this field, do you understand this contentious issue? But are you aware of research or studies to show that drug treatment facilities just don't have a disproportionate impact on crime?
Oh, absolutely. I was a committee member for the Safe Park Heights Initiative. Dr. Phil Leaf, who was the chair, and Dr. Daniel Webster from Johns Hopkins School of Public Health did a study that were the condensity of liquor stores and the relationship of crime, and there were no correlationship between treatment facilities and crime. It was absolutely none. And if you reference to the 2012 lawsuit that was filed by the directors, the police department made that same assessment and statement in their paper. And I don't know, council, the board have access to
They'll
that?
have the case in front of them. And I guess along those lines about public safety, like if in your experience, especially as a legislator, if a property is vacant, is that a bigger risk to the health and safety of a community?
I think that's almost a given when you look at all the abandonments throughout the city, where that's where drug activity and vagrants and all these quality of life issues come into place. I think it's more likely for that activity to flourish as opposed to having a building. And even the council person had said that, you know, we thank you because the building prior to this building permit and conditional use had been vacant. So, and the mere benefit, and I offered this to the community association, I said, I'll be willing to hire people in close proximity to the facility.
I guess just to wrap up here, that sum up about opponents' concerns and one of the letters had raised issues about operational issues. And without going through point by point, can you confirm with the board that you'll comply with the applicable state and federal rules and regulations?
Well, that is almost a given. In order for us to get CARF accreditation, now any residential facility besides those residential facilities that have use by right, that's 17 or below, you can open a group home up and you may see a lot of those proliferating within the community. But when you have 17 or more, in order for you to get a license from the Office of Healthcare Quality, you have to be certified that you're meeting national standards, best practice to operate a facility. So to answer the question, yes, we will be in compliance. And you have quarterly audits by state health department. You have audits by Baltimore Behavior Health Systems. And matter of fact, the Baltimore Behavior Health System brokered or tried to coordinate a meeting between CMDS residential and the community association to come up with a neighborhood benefit agreement. And I was all for it. And I was willing to sign at that time to debunk some of the misinformation that was out there about this was going to be a methadone program.
I guess just to close, like, to hammer home the lack of external impact. I mean, this might be an older street view photo, but the windows will be, like, no one can tell what's going on inside if you're walking on the street or driving by.
Right, absolutely. We had all of the windows in the facility. There's a reflection where they can see out but no one can see in. And that covers two aspects. It protects the person's confidentiality. It complies with HIPAA standards. And I just think just being a good corporate neighbor, that you want to do anything that could present a problem. And that's why we went to the extra measure to actually install all of that reflective glass on the facility.
Okay.
Mr. Williams, Mr. Pellegrini, do you want me to elevate him as a panelist or do you need him?
I don't think so, unless there are specific questions the board has or community members have that he would be better suited to address.
Okay.
I guess we can, oops, I'm fine. And for the, it says a closing, and I provided this to the staff about the considerations the board is to consider in granting the conditional use. So again, just to reorient where we are and what we're asking for is that if the board determines that our legal arguments that we initially provided fail, and that we need to either seek approval permanently for a change in the conditional use or for a reestablishment of the conditional use. These are the standards set forth in the zoning code the board is to consider, and they're all listed out. Just draw your attention to some of the points in closing. This has been a facility for 50 years, been in the same location. Residents will not be permitted to leave unsupervised. There's security at the doors and windows. And most importantly, this is in harmony with the purpose and intent of the zoning code. The biggest ongoing public health crisis the city faces, especially as COVID-19 is waning, is the opioid epidemic. And this use will promote the health and general welfare here. There will be fewer residents will not have vehicles, approximately 20 staff on a peak shift. Again, no changes to the building exterior, no expansions are proposed, only just making the windows locked so that no one will be able to see what's going on inside the building. The sign on the building doesn't say it's a drug treatment facility, it says Fayette House. So there will be no real change in the character of the neighborhood and how this will impact it. And this use represents a $5 million investment in the city and will provide additional 136 beds of capacity if people seeking treatment. And just to close our side, and we'll preserve for rebuttal, is that addiction is a disease, and we know everyone's not cured by a stint in rehab, but the facility represents a opportunity for hundreds of lives to be improved individually, and factoring the families and the people they know and the people who would be impacted if they were out using in the community and having the deleterious effects that it has an impact on thousands of people. And so we ask the board to grant our conditional use if it determines the legal arguments have failed.
Katie, this is Sabrina. If there's a natural stopping point, can we take a quick break? Maybe like 5-10 minutes before the.
Yeah, absolutely. Mr. Williams, do you have any other witnesses that you were going to call?
No, so I just had Mr. Pellegrini available if there's a unique question of operation.
Okay. Does the board want to ask any questions, or do we want to take a break now and then come back in 10 minutes?
I will have a question for Mr. Williams. It's a legal question, but we can defer that until we get back from the break.
Yeah, I'll have
Okay.
a question.
All right, sounds good. So if everybody's in agreement, can we come back at 4 o'clock?
That's fine.
Does that work? Okay, let's go.
Thank you.
Thank you. Okay, I think it's 4 o'clock. I think we're back on the record. So it's still with you, Mr. Williams. The ball is still in your court. Now the board has questions.
Feedback again from the chairman.
I don't know what to do about that. I can't ask you a question if I'm muted, so. I'll just do it while my dogs are barking about that. So one question I have goes to, I guess, part of the genesis of your legal argument in terms of, the definition of assisted living facility or residential care facilities. Prior to, I think my research is accurate, and prior to the new code in 2017, the 1971 zoning code listed several possible uses with regard to, I guess, what are now residential care facilities. There was a convalescent home, an adult daycare center, and also a residential substance abuse treatment facility. And now, what I understand from your presentation and also consistent with documentation you took, is that, all those things are lumped into residential care facilities now. Does the fact that the prior use was an assisted living facility or convalescent home and was not a residential substance abuse treatment facility, when that was one of the particular, possible uses that one could have identified in the prior code, does it change any of your argument now that a residential care facility is a residential care facility, whether it's substance abuse treatment, nursing home, assisted living, any of that? Do you see any distinction because the prior use involved what was clearly convalescent homes or assisted living facilities, and was not a substance abuse treatment facility previously, but now will be? Does that change your argument at all?
No, it does not. And so, I mean, the Transform Baltimore zoning code, the theory behind its use categories was that they were being expanded to be more generic. So not just residential care facility, but cover different types of uses, whether it's nursing home or residential substance abuse treatment, but types of stores, like, so under the former zoning code, the type of a store was spelled out specifically. So there are florist shops and drugstores, but now they're all categorized as a retail goods establishment. And that's how they're treated. And this is the same way here. If all the uses that were formerly separated and spelled out distinctively under the old code are now grouped under residential care facility. And the planning staff in their report, Mr. French's report from 2017, mentioned that, to his view, the assisted living facility use would be a residential licensed care facility use. And the zoning administrator's letter issued determined that either the prior use of assisted living or a nursing home would be a residential care facility under the current code. And so under their reading, and then how the code treats other types of uses, to treat this use differently, we think would be singling it out, and would have at least a discriminatory impact, if not motivation, to be singled out and not treated the same way.
Thank you.
I have a question for Mr. Ali. Hello?
You there? Yes.
I'm looking at an aerial shot of your property,
Mm-hmm.
and I can't tell, is there a fence that goes around the full property?
Yes. Parallel to, on the right side, there's a fence that goes all the way around, and it was a roofing company. So yes, there is a privacy fence around the entire program. Yes.
Okay. So you mentioned fresh air breaks a little while ago, and mentioned that some people will be in the pool, in the ping pong table, etc. For those who want to go outside, what area will they use here in the back of your property?
The back area,
I'm sorry.
maybe.
I'll share it again. Sorry about that. Yeah. So this back area here?
Yes. Can you see it, Mr. Cunningham?
I'm looking, I see a parking spaces, I see a green
Right.
space.
That's the area that they would go out for the break.
Okay, thank you.
Mm-hmm.
That's all I have for the applicant for now. However we want to approach the opposition.
Okay. Looking at the attendee list, so we have 51 people on the attendee list. Based on letters of opposition, we have letters from community associations. I've identified presidents of community associations that are on the line. We do know that the Westfield Neighborhood Improvement Association, their president, Angela Jenkins, is on the line, as well as John Murphy. And John Murphy, I believe, is representing Westfield. So it's probably best to start with the attorneys, right? And then I'm thinking work our way through the presidents of the association and then down to the individuals. I think that might be the best path forward.
Yeah, that would be helpful.
Is the councilman on the line also?
I did not see Mr. Dorsey a moment ago, but I have his letter. If Mr. Dorsey doesn't pop on, I'll be happy to read his letter of opposition into the record if we need to.
Okay.
You have that in your packets.
Right.
Okay. All right. So we'll start. Mr. Williams, I'm going to take the ball back from you. All right. And now I will find Mr. Murphy. Mr. Murphy? Hold on a moment. Let me unmute you. Mr. Murphy?
Yes, ma'am. Can you hear me?
I can hear you. Do you need the ball for a presentation, or are you gonna that you want to share your screen?
I need to share.
Okay, I'm gonna pass you the ball then.
I don't know what that means.
Well, it's figurative and it's literal because it's a little ball on my screen that I drag and drop to you. And you are now going to be the presenter. So I've given you presenter privileges. So you should now be able to share your screen. So at the bottom, you should be able to see an arrow that allows you to share.
Okay. Okay. Now, can everybody hear me?
Yes, sir.
Okay. My name is John C. Murphy. I represent the Westfield Association and some individuals. I have a presentation I'll go over, but I want to start off with the first exhibit. It's table 1, table 10-301. Get this. This is 10-301 of the zoning ordinance. This was adopted 4 years ago, transformed Baltimore. It says explicitly that residential care facilities of 17 or more residents are a conditional use given by ordinance of the city council. That is my basic position. We heard today a great deal of evidence on the features of this facility, the criteria that the board ought to consider in granting a conditional use for this facility and a great deal of legal argument. I submit all that is irrelevant. The basic issue today, and we live in a democracy, and we have to follow the law. The law says that a residential care facility is a conditional use granted by ordinance of the City Council. That's the basic point here. I want to go over the history of this property. It got started in '71. At that time, apparently, it was the zoning ordinance was just taking effect then. I've been around a long time. I can remember that. Perhaps it wasn't under the new zoning ordinance, it was under the old zoning ordinance. But in any event, it was classified as a permitted use in the B3 zoning district. And I show you all the approvals going back over the years on this property. And at some point I don't know the exact year, but it became a conditional use so that nursing homes were classified as a conditional use. They were no longer a permitted use. There was a provision of the zoning ordinance, section 3-306, that said any existing permitted use that was classified as a conditional use automatically became a conditional use. So then at some point after 1971, it became a conditional use. This is very important. Then later on, it operated as a nursing home from '71 up through 2013. And then we had an application before the Board of Zoning Appeals in case number 2017-195. And the applicant said in the application, it was built in 1971 as a nursing home. The building was operated as such until 2013. So it ceased use in 2013. And I would like the board to reflect on this. It's been vacant ever since. It's never had a use since 2013. Then and again, he said it was the next page. Again, he said it was used until 2013 and it sat vacant until they purchased it in 2015. So the point is that in 2015, and here's the resolution approving it, the assisted living and adult daycare. So then in 2015, the conditional use lapsed. Why? Because the code said, the code 14404 says, when a conditional use ceases for 2 years, it ends. So the conditional use stopped, the nursing home stopped in 2013. Then in 2015, it ended. It was over. Then we have the approval, and this is very important for the board to reflect on this. The approval in 2017 of a 38-bed assisted living facility. That's what they approved, an assisted living facility, 38 beds, and a 90-client adult daycare facility. That is what they approved. They didn't approve a conglomeration of residential treatment facilities. They approved this specific use in 2017. And the applicant makes a great deal of stress placed upon the letter from Mr. Veal in 2018. It was written to Mr. Williams. And the letter says, the property is currently authorized as a residential care facility for 104 residents. By that, he clearly meant the nursing home, which was 104 beds. It wasn't the assisted living facility. It was the nursing home for 104 beds. And he said that the current conditional use may be continued. And I've known Mr. Veal for a long time. I remember when he worked in your office in the Board of Zoning Appeals before he became zoning administrator. He's a fine man. And what happened here is that according to the records of the zoning office, the conditional use was still in effect because nobody had said anything to the zoning office that the property had become vacant. And that is how Mr. Veal came up with this determination that the current conditional use may be continued. But you see, he wasn't aware of what I've just told you, that the use ceased in 2013. And so then in 2015, it became, the conditional use lapsed. So Mr. Veal's statement was incorrect, but it was understandably incorrect because he didn't have the records. He didn't personally know whether the property had become vacant. The explanation there is that one of my clients asked Mr. Veal how he could have written the letter. And he said, here's his explanation. I believe that the letter was drafted without knowledge of the history of the property's use being discontinued for over a year. And he goes on to say that if it had continued, then the conditional use would have for the nursing home would have carried on to the new zoning ordinance. But it didn't continue because he said he was not aware of the fact that there had been a vacancy since beginning in 2013 as set forth in the affidavit, and therefore the conditional use was no longer in effect. So this is very important because Mr. Williams made great stress upon the fact of the estoppel and that sort of thing that took effect because of reliance upon this letter. But Mr. Williams, I'm sure, and everybody else was well aware that the property was vacant, and therefore the conditional use had lapsed. We go on to later on, having trouble getting can't get this. or here it is. You know, there's one entity that doesn't have any dog in this fight. And that's the Department of Housing and Community Development. And Senator McCray asked some questions about this use, and they investigated it and told him what the situation was. And in that letter, they said there was no indication. They described the conditional use granted in 2017 for the 38-bed adult daycare center and the adult day or the 38-bed assisted living and the adult daycare center. And he said it was no indication it was ever used as the BMZA approved, and only some construction occurred prior to current owners beginning extensive rehab. This again is very important. And again, I point out to you, this is a bureaucrat, Deputy Commissioner Hessler saying this. He's not my client. He's not a proponent of the applicant. He's a city official, and he's giving a determination about what was the use of the property. And he's saying there's no indication that the use was ever used. And in Mr. Williams's testimony, there wasn't any indication that that use was ever used. There was a permit issued, but there was no indication that the use was ever used. Now, here's the situation, it seems to me. Mr. Williams has made a determination of two, he's relying upon two approvals, might say, by the city. The first is Mr. Veal. It seems to me that clearly Mr. Veal's determination was incorrect. Mr. Veal said the same thing. He said it was not a permit, it was just a letter of advice, and he didn't have all the facts. Whoever signed the letter on his behalf didn't have all the facts. So it seems to me that we cannot say that that letter gives any approval for the property, for what occurred, because it was incorrect. And I cited cases, I wrote you a letter, and I'll cite the case at the end. Even if there was a permit issued on that basis, it would not be valid because the law did not allow it. That's one point, that the 104 nursing home was not something that could be carried over to the new zoning ordinance because it had gone out of existence. That use had ended in 2015, 2 years after the use ceased. The use ceased in 2013, 2015, 2 years later, that use ceased. That's the first point. The second point deals with the approval for the 38-bed assisted living. And I would like the board just to reflect on this for a moment. What you're being asked to do is to approve a rehab facility on the basis of 136 room rehab facility, 136 bed rehab facility on the basis of a 38 bed approval assisted living back in 2017. I mean, I spoke about democracy and rule of law and that sort of thing. I don't need to I don't need to tell the board about that. I very much admire the effort that you've put in hearing these cases over the years. I've known Mr. Cunningham, I remember when he was a councilman from this area, I believe. But just put yourself in the shoes of these citizens here. When the application came up for a 38-bed assisted living facility, nobody appealed it. Nobody had any problem with the 38-bed assisted living facility. That's not the same as a 136-bed drug treatment facility. It is not. They're two entirely different things. As I say, I started off this by saying that this matter should be before the city council. Mr. Ali can come and explain all the features of this facility, but the city council, when they enacted Transform Baltimore, they made a specific determination that all these facilities were part of a conditional use by ordinance of the city council. That's where this matter belongs. It is really a denial of due process to suggest that the board approve a drug treatment facility when there's nothing in the ordinance now authorizing the board to approve a facility of this sort. It's just not there. We enacted Transform Baltimore 4 years ago. Now, with respect to the 38-bed assisted living facility, there are several reasons, 3 reasons, I would say, why that really is not relevant at all. First of all, it's an approval of an assisted living facility. That is not what we're here today about. Secondly, when Transform Baltimore was adopted, there were very specific provisions written into it called transition provisions. And it said, for example, previously granted variances and conditional uses remain valid. It said that in 2203J1. But it said any subsequent change to a conditional use is subject to the procedures and requirements imposed by this code on conditional uses. It says any subsequent change to a conditional use. Okay, the conditional use was granted in 2017, and it was for 38-bed assisted living. 2203J of Transform Baltimore, specific provision written for, it's called transition provisions, says any subsequent change to a conditional use is subject to the procedures and requirements imposed by this code on conditional uses. I mean, I have the highest respect for this board, but there's a principle of law that everybody follows, and that really is important in a democracy, and that is the words have meaning. You follow the words of a statute. It says any subsequent change to a conditional use. There's no way in the world that this cannot be considered a change to a conditional use. from 38-bed assisted living, the use itself has changed, to 136 drug rehab facility. It's totally different. And I'm not really in any sense implying anything about whether the drug rehab facility is a good facility, bad facility, whether it ought to be approved by the city council or not. But I'm saying that clearly it's a matter before the city council because there has been any subsequent change. Now, there's a rule of reason, I'm sure, that not every minor change is subject, but something as major as this has to be considered a change. And finally, I would make the point that just bear with me for a minute here. Expiration of approval. It says, this is section 5408 of Transform Baltimore. If any conditional use is discontinued for a continuous period of 2 years or more, the conditional use approval automatically lapses and is void. A new application and authorization is required before the conditional use may be reestablished. Again, any conditional use is discontinued for 2 years. It lapses and is void. A new application is required before the conditional use may be reestablished. That's 5408 of Transform Baltimore. Again, these are clear words in the English language. They mean something. They mean a great deal. When a conditional use ends for 2 years, one has to come and obtain a new one. Go back for a moment to what I said before, quoting Mr. Hessler, that this conditional use was never even established. There wasn't any indication that it ever operated. But even if it had in 2017, it's been more than 2 years since nothing's happened on that conditional use. I guess what the applicant is saying is that their conditional use sort of piggybacked on the 38 assisted living conditional use. I don't buy that. I think they're totally different. But that's not what this ordinance says. This ordinance says if any conditional use is discontinued. I again refer to what I said at the beginning here. This nursing home was established in 1971. It ceased use in 2013. There hasn't been a use there since then. There have been permits issued, but there is no use. The building has been vacant for 8 years, since 2013. The conditional use that was established in 2017, even if it's considered to be, even if it was considered to have begun, it ended right away. Hessler said there's no indication it was ever established. So it's That's 2017 is, what's that, 4 years ago. It's got to have been lapsed for 2 years. I mean, that's the reality here. That's the long and short of it. I'm not in any way saying whether the board ought to approve this, not approve it. My only point is it needs to go in front of the city council. That's what the ordinance says, and that is what the board ought to do. This is a very important. I was out at the property the other day, and I saw a sign advertising this hearing. Well, that's a very big deal for the residents. But there's been no hearing on whether this use, this drug rehab facility, ought to be approved or not. There needs to be a hearing on whether this facility ought to be approved or not. And the entity conducting that hearing is the city council. This board, with all respect, there's nothing in the ordinance allowing, which Mr. Williams fervently asked for, the board to approve a conditional use for this facility. There's nothing in the ordinance allowing that. Thank you very much.
Thank you, Mr. Murphy.
Okay, Mr. Murphy, I'm going to take the ball from you. All right, we have several community association presidents. I've heard from 2 of them that have asked an immediate neighbor to go first. So I'm going to unmute Miss Rochelle LaChance. She's Community Association for North Hartford Road, and I believe she has one of an immediate neighbor to testify. Miss LaChance?
Okay, I'm going to pass it on to Quasi.
Okay.
Talk very slowly.
Yeah, and if you could spell your name, sir, and everyone that testifies, just please spell your name first and last for the reporter.
My name is Kwame Asaf Ajay, and the Kwame is Kwame. The last name is two letters, 2 words. First is ASAFO, and the last one is ADJEI.
Go ahead, sir.
Yes, I am the resident and owner of property 6025 Old Hartford Road. And my house is separated from 6040 Hartford Road by a common fence.
I'll clarify. It'll make it a little easier. So he's saying that his house is separated from the facility by a fence.
A fence.
Okay, go ahead.
Yes. I've been in this facility, in my house, for over 20 years.
He's been in his house for 20 years.
Okay. And during this period, we had the nursing home. And the nuisance of nursing home led to so many of my neighbors leaving the area.
So he said they had the nursing home there, and that the nuisance of the nursing home led to many of his neighbors moving.
I don't mean to be rude, but whoever the woman is speaking, it's unnecessary. We can understand him perfectly.
Okay. Then that's
and it's
fine,
more
please.
feedback.
Okay, thank you. So I've been there all this period. Okay, the nursing home closed 2013. And ever since then, there have been no operation whatsoever in that building. You know, and I have been a correctional officer working at the Petopsin Institution also over 24 years. And in Petopsin Institution, we have mental health facility dealing with the people, kind of people that they want to bring into the facility. And in fact, in all fairness, this is not a program which can be inhabited in wherever they want to put it at this place, because it's not fitting for the area. The people that cannot be contained in this small facility that they're talking about. They're talking about a backyard. The backyard, how big is it? Where is the space to contain these people? There's no space. And I will invite the zone board to come physically and see for themselves, because what we have been told here is entirely different from what is on the ground. I have been a correction officer. I've dealt with the patients that they're talking about, the kind of patients they're talking about. No. What kind of security are you going to have to contain these people? Please, I'm not going to talk, there's so much about the law, but physically, what they are trying to tell us, or what trying to impose on this area, cannot be accepted. How many security, what kind of training do they have, the so-called security people? Are they properly trained to contain these people? It can't work. Please, I've lived with them. The fence that they're talking about, I wish you all to come and see the kind of fence they're talking about. These people can easily jump over it, and they will be in my yard. Like Attorney Murphy said, this is a matter which should go to the City Council for us all to come and give vivid evidence, like in court, for the zone or whoever is there to decide, to have the facts upon which to make what do you call the decision which actually can be they have to determine 10 facts before they can come to a reasonable decision. As we have been told here, it doesn't help anybody. And I'm sure you all know the law of nuisance. And these people are a continual nuisance on the neighbors. And they're going to be, yes, the noise and their behavior, 24 hours non-stop. I live in Patterson, and I know how it is. It is not a joke, as we've been told here. Yes. It's not a joke like I've been told here. The facts as they stand. If you don't know anything, please, Patterson is not far away from you. You can get first-hand information from Patterson Institution. Yes, it's a 24-hour nuisance. And you need well-trained security officers. Security officers contain the people that you are trying to bring at my backyard. Please. The things that you're talking about can easily be jumped over by these people. Yes, they will jump over it. And 6025, where I live, 6027, 6029. Please come to the yard and see what they're talking about. Thank you.
Okay, I understand that Ms. LaChance, that both you and Ms. Jenkins were okay with letting Ms. Green, Ms. Tawana Rollins go. She is an immediately adjacent neighbor as well. So I will come back to you, okay?
That's fine.
Ms. Rollins?
Yes, I'm here.
Okay, go ahead and
Good
speak.
afternoon, everyone. Okay. My name is Tawanda Green Rollins, Tawanda. Green like the color with an E. Rollins, Rollins. I live at 2901 Christopher Avenue, which is on the side between Old Hartford and Hartford Road. September 2012. So we've lived here a little over 9 years. And when we first moved here, the nursing home was open. And there was some traffic, but within a year and a half that we lived here, the nursing home closed. And so, there wasn't much traffic there. My daughter attends Hamilton Elementary Middle School. And my concern that I have about the facility is really about the amount of traffic that will start to come through this community between the school with young learners. And that is a great concern for me, especially when they're walking to and from school, because the children who go to Hamilton live within this community. And I'm concerned about the traffic that they will see going to and from school every day, and how that's going to impact not necessarily their safety, but just their security of their environment. Many children attend after school the library at the corner, so they're walking between Old Hartford and Christopher and the 7-Eleven. Forgive me, I forget the street right now, but they're walking to the Enoch Pratt Library that's on the corner of Old Hartford Road and East Perry. So they're passing the facility every day. And if no one is there to control what they are seeing and hearing and what people are doing with young learners, it can be influential. And I do not believe that they need to be exposed to those things right now in life. I'm also having a concern about the other facilities that are in the neighborhood that I didn't really even know exist initially, but they are here. And so is that facility necessary in addition to all of the other facilities that are in the proximity of the school and this new facility that wants to open? I'm concerned about the space in the library. As I said, if residents don't have adequate, as the residents of the facility don't have adequate recreation and resources, what other resources are they going to have to be, open to in the community if they don't have adequate space in order to do whatever therapy or rehab that they will be exposed to, right? And so I'm concerned about that. I'm concerned about the traffic. I'm concerned about the children. I'm concerned about it being so close to an elementary middle school. I'm concerned that there's other facilities in the community which are already here. So why is this one necessary? And if the facility has been closed for this amount of time, and if we're thinking about rebuilding and reestablishing the community, and there's already facilities in the community, why is this one also a necessity? And like I said, the facility has been vacant for years. And we have seeming to be just fine there. I'm really concerned about the traffic and what children will be exposed to, and my child in particular, along with other children who attend Hamilton Elementary. I'm not sure it's right in addition to what's already happening in this community. Thank you.
Thank you.
Okay, next one we have is Miss Natasha Winston. Again, was a request for another immediate neighbor to go, and then we will get back to the 3 community association presidents. Ms. Winston?
Hi, good day, everyone. My name is Natasha Winston. I'm NATSHAWINSTON. I am a longtime parent of 2 students at Hamilton Elementary Middle School and a longtime parent advocate of public school education. I am speaking to you on behalf of the children. Hamilton has a long tradition of educational excellence and support for its diverse community of students. It is one of the highest achieving schools in Baltimore City, and in a time when the total enrollment of Baltimore City schools and the city has declined, Hamilton Elementary Middle continues to grow. In the last 10 years alone, it has grown from just over 600 students to almost 890 students. This is a testament to the hard work and dedication of the faculty and staff, as well as the sustained support from the families, community, and other partners. We are one of 15 gifted and talented sites in CD School and offer one of 4 ingenuity program sites. We teach science and engineering, technology, reading, language arts, social studies, and social justice. We have vibrant visual and fine arts programs and the second largest band in the city with over 120 students learning musical instruments. Educating children is no easy task. Our teachers work tirelessly to prepare highly engaging, rigorous lessons that prepare the students for high-stakes testing, competitive high schools, and a future that we as adults cannot yet envision. We are also responsible for preparing our students to be valuable and productive citizens, as well as adults who are well-adjusted, socially responsible, and emotionally sound. Did you know that on a daily basis, we teach social emotional learning, conflict resolution, and restorative practices? And we do all this in the midst of a city which by many accounts is in crisis. Our students are fully aware of the hardships faced by Baltimore City. They are part of that fabric. Too often, they are also on the front lines of the violence and emotional pain that we as adults would be hard-pressed to manage. But we do it every day. And some days are harder than others. Some days the anger, hurt, frustration, and pain get the better of us, and we hurt each other in the process. But we still come back every day. At 95%, Hamilton has one of the highest attendance rates in the city. Our children want successful futures and are ready to learn. Our children are resilient, even when they shouldn't have to be. Our children deserve a childhood that too many adults are not willing to fight for. This is not about not in my backyard. This is about the right to transparency, the right to be part of the decision-making process, the right to truth and honesty from the adults who are charged with protecting their childhood and enriching their futures. Opening a treatment facility within 500 feet of a schoolyard without these considerations show us that, once again, we are advocating for everyone but the children. When is it their turn? Thank you.
Mr. Chairman,
Yes, sir.
I'd like to suggest that we try to put maybe a time limit on the length of comments and ask folks to stick to a point.
Yeah, and keep in mind, folks, where we are on this matter and what we'd like you to state your objection. If the objection has been stated, now, granted, objections can be stated different ways, but the same objection. If we know there's a traffic issue, the issue of it being close to children, close to schools, we understand that, and that's a record has been made, a sufficient record has been made of those issues. So we really don't want to use this as an opportunity for, to be heard just to be heard, but we really are looking for additional information to consider to reach a resolution. So please be mindful of duplicate testimony that we really don't want to have, because I will begin to interrupt and interject so we can refocus on the issue that we need to hear. Thank you.
I'd like to say what was helpful for me is whoever the last speaker was, it's clear that she prepared her notes. So if anyone has things that are concise and prepared, that's probably, those are the people you want to advocate on your behalf.
Good point. Thank you.
Okay, we will now move to Community Association Presidents. I'll move to Miss Angela Jenkins, who's the President of Westfield Neighborhood Improvement.
Oh,
Ms. Jenkins?
I tried to turn my, and
Hold on. If you can turn your camera on, that's okay.
am I on?
We can hear you. Oh, you know what? Did you have something you wanted to share, or?
She's not a presenter, right? So we wouldn't be able to see her face.
No. I mean, that's true. Let me see. I can't seem to make her a panelist. There you are. Okay, Ms. Jenkins.
Hi. So I do, I would like to mainly read my letter, but I do have a couple of photographs that I don't know if these are the most updated photographs of the back of the CMDS Fayette House facility. Are you able to see my screen?
No, and it's not allowing me to have you become a panelist. If you'd like to email me those photographs.
All right, I'll have to do that because I do have all the photographs that show how close
just one moment, Katie. I think maybe we have too many people.
Oh, maybe.
Leah Barron is still logged on as a presenter, and I don't think we need her for this matter.
Let me see if I can get her out of there, and then maybe we can elevate her. That's a good suggestion.
And Mr. Murphy for a while. I mean, he can obviously come back, but like, we don't need him for this particular part of this presentation.
All right, so stick with me just one moment, Miss Jenkins. Let's see.
While you're doing that, Ms. Byrne, to the extent that we have a letter already, we really don't need you to read your letter. It's part of the record. It's part of the packets that we've been provided, so we're aware of what's contained in them. We have read them, we have considered them, and we will continue to do so. But we really don't need a regurgitation of what's already provided in the record. If there's anything more, if there's something in response to what has been presented by Mr. Williams' presentation that is new.
Sure, I could speak off the cuff then, if that would be preferable. I am concerned that the facility CMDS Fayette House had a really significant amount of time to speak, and when the community is coming on board to speak, we're being wrapped up rather quickly.
But you mentioned that you would like to read your letter. That's my point.
I thought
we don't need you to read the letter.
Yeah.
We can hear your testimony, but we already have what's contained in that if you'd like to read the letter. That's my point.
Okay.
Go ahead.
Do I have the ball? Is that possible?
No, I can't.
No,
for whatever reason, it's not allowing me to make you a panelist. We've even put people out of the group, and I apologize. It's not allowing me to make you a panelist.
Okay, I did have photographs. I wasn't, we're at a little bit of a technological disadvantage. I'm using my daughter's Chromebook. I wasn't able to get the audio on my laptop. We had neighbors go to each other's houses. I think the transition is, we do not have beautiful PowerPoints presented. One point I would like to make is a lot of what I saw in the previous presentation by CMDS Fayette House were things that I'd like to talk about at a city council hearing. We are interested in discussing quality of care and the future of treatment in Baltimore City, and what would be the right kind of measures to stave off the opioid crisis. Both my parents passed away related to addiction. I'm not really sure what some of the comments were that I heard. This facility, we're concerned about CMDS's track record. We're concerned about the zoning. We didn't know anything about the purchase of the property. Letters were already being written, and exchanged where there was a miscommunication related to whether or not use and occupancy existed. The community was left entirely out of that dialogue. We found out for the first time about this facility when they said they had already renovated the building and were about to open, and they were telling us, that they approached the community association and said they'd like to have 150 people in the building, and if we couldn't approve that, then they would have to supplement with outpatient program, which they said we really don't want to have next to our school. And that has been the dialogue, which is not what a treatment center, that's not the relationship a treatment center should have with the community. We are very interested in making sure that the residents in our community have treatment. We want it to be a quality treatment. We've seen the proposed budget of this facility pulling in something like $10 million a year with an estimated profit margin of about $7 million. All of that is something we want to talk about at City Council hearing. And I do have photographs that show that the backyards of residents are right up in the parking lot, and people they already were moving away because of the nursing home. And as Mr. Kwame stated, they started to move back after the nursing home closed, because the building itself is just situated right on top of residential properties. And we're concerned about revolving door. And honestly, we have no idea what this facility will look like, but we do know what Turning Point looks like, and we're concerned about that. And I think I'll just leave it there, and I'll let other people speak, since my letter's already on record.
Thank you, ma'am.
Thank you. I'll move back to Miss Rochelle, the president of the North Hartford Road Community Association.
For allowing me to come.
Ms.
Can you hear me? Yes. I'm Rochelle LaChance, Rochelle, last name Lachance. Thank you very much for allowing me to come and testify today. I will try to keep my testimony to 2 points. I am a licensed clinical social worker. I have 39 years experience. I have worked directly in substance abuse treatment at Johns Hopkins Bayview Acute Psychiatric and Dual Diagnosis. So I understand these patients. I've worked with them. I've done discharge planning. I've set up treatment plans. I've worked with families, all of that. So one of the concerns that has really, once we heard about this facility, I wondered why anybody wasn't reaching out to the owner of the facility, because I wanted to know more about the program. I wanted to know why you would stick a 104-bed program in a community next to 2 bars and next to a school in a place that was already saturated with, we have somebody who will present a map of the saturation of treatment programs we have in this area, why you would put it there. And so I wrote Kevin Pfeiffer, the owner, and I sent him a copy of my letter of concern with my concerns about the facility based on what I knew about CMDS, which are the 4 letters that sit before the name of this facility and are plastered on the building. And what I knew about CMDS was not good. And what most of people in Baltimore know about CMDS was not good. So we were confused when we had a meeting with Belal Ali in February of 2020 at the Church of the Messiah about exactly what this facility was about. And I asked a lot of questions about the treatment planning and the facility and the types of treatment and how many and the philosophy and whatnot. but he seemed to allude to the fact that if the beds were not approved, that they might open an outpatient facility. So I wrote Kevin a letter, and I'm going to read 2 paragraphs from his response, and then I will finish my presentation based on that and try to stay focused. So after I asked Kevin about why he would want to open this type of program, and I was concerned about the zoning because we did not know that they had zoning because we had never been involved in that. Kevin wrote me back, and I have this in an email, and it said, "Do you truly not realize that 6040 Harford Road is only capitalized, zoned as a residential care facility and not as an outpatient facility? How can you not know that it is only capitalized zone for residential treatment? Do you suppose I would have purchased it and the bank would have lent rehab dollars if the zoning were not entirely consistent with use as a residential care facility? Why would I have spent millions making it easily the finest such facility in or near the city of Baltimore? Could I be that dim-witted? Do you want it to be a residential or an outpatient or a methadone? There is no zoning classification that would permit both, so choose. And no, it's not really helpful to say the community wants to see a 4-star Seasons hotel go in instead." So 2 points I want to meet in this is, well, 3. The zoning, the fact that he said it's the finest such facility, and the third, that the community sees a 4-season hotel. Kevin would have been quite upset to learn that he had gotten erroneous information about the existing use permission that existed on the property. And he was told it had an existing permit for residential use. He's not a lawyer and he's not engaged in matters like this, but he would have no understanding of why or how there should have been questions. So it must have been pretty awful for him to find out that this facility was had not been zoned for conditional use.
Ms. LaChance, can I interrupt you for one moment? I just got a message from the court reporter. She has to change her batteries. Can I get you to pause just 1 second?
Sure.
Thank you.
They were going to cut me off. I am. Did that sound okay? Mm-hmm.
Just a couple more seconds. She's gonna put in the chat when she's ready. Okay, you can continue. Thank you.
Okay, so since Kevin's not a lawyer and he wouldn't have any understanding of this, he hired a land use attorney. Once he learned that there was question about the occupancy permit, yet somebody on the front end of the people representing him should have put 1 and 1 together and realized the property had been vacant for so long that any use permission that ever existed would be dead. Of course, he didn't know that. So the fact is that even though this is the case and that they could not really rely on the letter from Mr. Vail, it is very clear that he didn't have automatic use of the facility and that we have a legitimate right as residents to contest their zoning for that use and occupancy permit. So we have a right to do exactly what we're doing today. Secondly, finest such facility. I have to say to you that I have worked in treatment a long, long time, and that a building does not make a program. We heard and saw beautiful and lovely pictures of the facility that they say is state of the art. Well, there's one ping pong table for 138 people, and the gym is no bigger than my living room. And they didn't show you the bunk beds that they are going to have in the pictures on the website, but they are planning to have, they have rooms with 6 in a room, 3 sets of bunk beds. Of now the 138 beds they're approving. Now, how do you go from 104 to 138 in a facility that hasn't even opened yet and proved that it is a viable facility that helps addicts? How since, in the last 2 weeks has it gone to 138 beds? So they're talking about there's only going to be 18 single beds in the whole facility. There's going to be 59 sets of bunk beds, so that there's going to be 118 people in bunk beds, but there'll be 59 in the top bunks. Well, if you've ever worked with patients who are undergoing, and I have to say that substance abuse treatment, I believe in it, and I believe that it has to be quality, and it has to be about the patient. All we heard was how beautiful the building was. Well, everyone knows that the only way that a person can manage serious dual diagnosis, addiction behavior is because they want to change and they make a commitment to change. Well, this facility is taking anyone who wants to come, and they are advertising on their website 3 meals a day. Well, I worked at Bayview, and when people wanted to get off the street and they wanted to have some rest, they checked themselves into the emergency room and they said, I'm suicidal. And so they got a bed as long as medical assistants would pay for it. And they went through the motions and they got their 3 meals a day and they left and they went back out to doing what they're doing. I don't hear that there is any criteria at this point for admission. They're taking everyone. They're putting 6 to a room. Their treatment of modality focus is not on the newer things that are used with substance abuse. You can put a person who wants to go in a $5,000 a month facility down in Florida with lakes and trees, and it's not going to work unless that patient buys into treatment. When Mr. Ali talks about all this great success, you have to look at his background and you have to look at the fact that he's worked at numerous places. I don't see anything in the record about the success of these places. He has many, many issues that can be looked at on Maryland Judiciary Case Search about some of his lawsuits and some of the fact that he lost his license, he lost his counseling license, and he was he worked at Gardenzia, and there was complaints of over 30 parents about the treatment of patients. So I want to hear what is going to make this program a quality program. I don't need to hear about the building. I want to know about the staff. I want to know what you're going to do to keep these patients busy all day. I'm going to close it up in a minute. I want to know what they're going to do besides play ping pong. You're going from 104 patients to 138. You haven't opened. Are you adding more staff? 1 ping pong table, 1 basketball court. I don't hear anything about art therapy, music therapy. Angela and I met with the executive director of the Turk House and their clinical coordinator, and we spoke with them about a quality program. And this is on tape. You can access it through Westfield Neighborhood Association. They said they would never put more than 2 patients in a bedroom. These patients are physically sick from coming off of drugs. These people have mental health disorders. You put the 2 together, you don't get well-behaved patients. And when you're putting 138 people, it sounds to me you're looking more like to make money than you are to provide quality care. Let me just see if I have any other point in my notes. I can't write because I broke my arm. The concern that there's no criteria for admission, the concern that they immediately want to add it up to 138 beds when they don't have zoning. The facility hasn't even proved that it has any benefit to patients. We're already saturated, and the bunk bed situation and putting 6 in a room is not indicative of quality treatment for people with dual diagnosis. And I thank you very much.
Thank you, ma'am, for your presentation.
All right, I'm going to move to Miss Mia Bloom, President of Hamilton Hills Neighborhood Association. Miss Blum?
Hi, this is Miss Blum. I'm having a hard time with unmuting, so I apologize. I stand by everything that is in our letter, and I'd like to defer to the Vice President of the Association, John Fowler, who actually is in closer proximity to the location.
Okay, I will put Mr. Fowler on. Mr. Fowler.
Yes, ma'am.
Okay, proceed.
All right. Hi, my name is John Fowler, JOHNFOWLER, testifying both in my capacity as Vice President of Hamilton Hills, as well as being a resident who lives within 3/10 of a mile of the proposed facility. As referenced in the letter of opposition by Ms. Blum and pointed out by Mr. Murphy, the building was non-operational since 2013. Thus, any prior use given was nullified. Per the current zoning code, the board lacks the authority to grant such a use, as it must be obtained by council ordinance only. I'd also like to raise that CMDS Director Bilal Ali was likely part of the voting process in his elected capacity at the time that granted money to ALF in a bond bill, which his council has now used in evidence of the building in his favor. Further, I think there should be some gravity afforded to the substantial amount of opposition, including every surrounding community association, rather than making the decision based on what amounts to semantics, comparisons between public stadiums and a clinic, and an example from Baltimore County. We stand in full support of every surrounding association in opposing the licensure and operation of this facility, and we ask that you please deny this appeal. Thank you.
Thank you, sir.
Okay, now I believe, let's see, Mr. Dorsey is not going to be attending the meeting. I've had other association presidents drop off, so now I'm just going to work through the list, starting alphabetically by first name in the beginning, and we'll go from there. Miss Richardson? Miss Richardson, would you like to speak? Alicia?
No, thank you.
Thank you. Angela Stolfus, would you like to speak, ma'am?
No, thank you. I'll pass.
Thank you. B. Hargrove, would you like to speak? Hello?
Not at this time. No, not at this time.
All right. Hold on one second. I'll go to the call-in users last. Danielle Pinder, would you like to speak? Ms. Pinder? Okay, no.
I think we're playing with the mute. I'm trying to unmute. And
Oh, we're mute. Okay, we're being counterproductive. Miss Pinder, would you like to speak?
Hello. I am not really. I'm just listening in. I am the community liaison for Nick Mosby's office.
Okay.
And so it was on my calendar to attend and to listen in, and I am very, very glad that I did. I have no real opinion. I do have an opinion, but I'm not necessarily going to speak right this second. But I do appreciate you guys. I appreciate the facility owner, and I appreciate the community members, everyone for their liberality and their willingness to speak and do something to help this population. So have a wonderful afternoon and evening, guys. Thank you.
Thank you. Diana Emerson.
Yes, hello. I will keep my comments brief. This is Diana, Diana, last name Emerson, Emerson. I'm the Director of Community Relations for Harbell Community Organization. So we are right up the road who, as a lot of the other community members have already mentioned, that there are other facilities in the community, including us. We have been here for 50 years. We have a great working relationship with all of the surrounding communities as it relates to community, as it relates to safety, as it relates to clinical practices. So we are in agreement with all of our community associations that have been represented here today. That is all.
You. Katie, are you muted?
Let's try that again. I was muted.
Okay.
Jennifer, Ms. Hamilton, would you like to speak?
Nothing at this time. Thank you.
Thank you. Okay. Joan Cauliflower, would you like to speak?
No, thank you.
Mr. Fowler, we've heard from you. Mr. Cleary, would you like to speak? Mr. Cleary?
Just listening in, thank you.
Okay. Mr. Josh Morgan?
Hi, can you hear me?
Yes.
Okay, I'll be quick. I would just echo what everyone else in the opposition has said that I've heard so far. I also would like to state for the record that I strongly resent the accusations of NIMBYism, and especially the accusations that our opposition is based on racial tensions within Baltimore City. I think that is disgusting to say, and particularly because our community associations and a lot of the neighbors that I talk to every day are from a diverse variety of backgrounds. I just want to say for the record also that this is more, in my perspective, a concern about the quality of treatment at the facility. I don't expect that stacking patients like cordwood for profit is something that should be looked at as a model for innovation. That seems more like profiteering. And I agree with everyone else that a city council hearing would serve the city well in looking at the future of treatment in our districts and our neighborhoods. So that's all I have to say. Thank you.
Now I'm unmuted. Mr. Moy, would you like to speak?
No, thank you.
All right. Miss Julia Clausen, would you like to speak?
No, thank you.
Miss Julie Lynn, would you like to speak?
Yeah, sure. Hi, my name is Julie Lynn, and it's spelled JulieLin. And I am a resident in Hamilton Hills, and I live not too far from the school as well. And I'm speaking on behalf of just a resident, but also a lot of the nonprofits and the community groups that we've worked really hard for the past few years to bring wonderful resources and help the schools improve, help the businesses. We do a lot of wonderful things and have put in many, many investments, not just, money, but human labor and sweat equity wise. A lot of wonderful things are happening in the neighborhood. And I feel like this the model that's being proposed here, as a lot of people have already echoed, is not patient-centered. It feels very profit-driven, and that is not, the best thing for people. And so I look forward to seeing, positive models or some other proposals that will be more beneficial for people. Thank you.
Thank you.
Ms. Karen Elliott, would you like to speak?
Yes, very briefly. Karen is Karen. Elliott is ELLIOTT. I don't have anything in particular additional to add to what has already been said in opposition to this, but I just wanted to note to the accusation that our concerns are related to NIMBY, that if that was our concern, not having any facility like this in the neighborhood, we would have spoken up against all of the other facilities similar to this that are already in the neighborhood, and we did not, because we recognize that it's necessary. I and other neighbors who I've talked to are concerned about this particular operator, considering things that we have heard about it. That's it. Thank you.
Thank you. Kevin Duvall?
Yes, hi. My name is Kevin Duvall, KEVINDUVAL. And I just had one question for Mr. Wilson, who had mentioned several times that by right, they could operate the facility as an outpatient methadone clinic. I was just curious what would prevent them from actually doing that, which is really one of the concerns that we have. Thank you, though, for everyone else. I echo the comments of Mr. Fowler and others. We are not being NIMBY. We are concerned about the quality of treatment. And thank you for giving us this forum.
Very well. Thank you, sir.
Kim Lane? Ms. Lane, would you like to speak?
No, I'm not. No, I'm just
Thank you.
watching. Thank you.
Lisa Overbrockling?
No, I don't have anything more to add that's hasn't already been said. Thank you.
Thank you. Marceli Barbosa? Ms. Barbosa, anything?
No. Thank you.
Okay. We're coming down here to the R's. Rob Neff, do you wish to speak?
Yes, I'll be brief. My name is Robert Neff, R-O-B-E-R-T. Last name is Neff, N like Nancy, E, F like Frank, F like Frank. The reason I've chosen to speak today, I wasn't originally planning to testify, but I have a PhD in geography. I teach urban geography and urban planning courses at Towson University, and I am not only qualified to conduct the kind of research that was cited by the CMDS folks, but I can train people to do it. That was the analysis that looked at the impact of treatment facilities on crime. And the reason to respond to this is simply that they're mischaracterizing both what the article says and also the way that the community is responding to this facility. So the article says that on average, there is no correlation between distance from a drug treatment facility, defined very generically, okay, and crime. And I have no reason to doubt those results. However, that's not the argument that's being made here. The community has been very clear that our opposition is not based on opposition to drug treatment facilities in general. We have no opposition to average drug treatment facilities. We have very specific concerns when it comes to CMDS, the way they have operated in other places. And more to the point, I find them to be an untrustworthy partner in the community. They have threatened to open an outpatient facility, despite the fact that they say publicly that they have no intention to do so. My understanding is that they have started the licensing procedures to open an outpatient facility at this address. I believe that they are deceptive in the way that they are displaying the information to this board. And I think that they know full well that they are casting the facility one way and depending on the audience. And as such, I think that we really need to have a much more detailed conversation with CMDS, and that can't happen through this venue. It really needs to happen in front of the city council. And so I'm asking the board to please, follow the law and refer this matter to city council and rule that they do not have the authority to approve the permit. Thank you. That's all I have.
Thank you.
Robin Redding?
Yes, thank you. My name is Robin Redding, Robin Redding. I've lived in the neighborhood for 40 years. I have concerns, just as has been stated by the neighborhood associations. I did go on a tour of the property, and as Rob said and other people said, the pictures are a little deceptive. The owner did sort of threaten that if we didn't stop our opposition, he would open up a methadone treatment center. Another thing is that while right now they're talking about just residential rehab, people who have already gone through detox, the owner did mention to me that a particular room which had its own private bathroom would be good for somebody who was going through detox when they actually got that. So they do have plans to be more of a medical facility at some point than just after people have gone through the rehab, which makes them more of a medical facility than just a very large group home. So I agree with the other comments and do have the problem with how they plan to operate. Thank you.
Muted again. Samuel Kimani?
Yes, I'd like to say something.
Okay.
First off, that Mr. Bilal Ali is saying this arrest issue, that is very insulting. We are a well-divided community here, about 46 white, 46% black, and we do get along very well. Most of the students who attend Hamilton Elementary, who will be walking right next to that facility, are black. So I'm not sure what he's thinking that who this is going to be affecting. The other thing is we all know this is a poorly regulated industry, and we are a fairly stable community. And what these guys want to do is introduce something that could be very destabilizing to our community. So I would urge the BMZA here to just refer this matter to the city council. Thank you.
Shannon Catano? We're coming down to the end here. We only have a few more.
Shannon Katona, SHANNONKATONA. I've been in the neighborhood 37 years. I've been involved on the periphery of chemical dependency problems, alcoholism since the late 60s. And I find it really appalling that this facility is going to go in and they, as has been said many times, what is the model of care? And I don't see anything, I haven't read a single thing that really says they care about that. They really just want to pick up Medicaid dollars. And this is not a good idea for anywhere. We would all love to have good treatment facilities for our addicts. We know this is a real problem. And I can't say that anybody around here would object to that. But this facility is not showing in any way, shape, or form that they are concerned about the community or the people that they are going to be housing. That's it.
Thank you.
Muted myself again. The next person is Miss Daphne, and I know she has put in the chat, but she doesn't have any audio. So Miss Daphne, if you would go ahead, if you want to testify, if there's anything you want to say, could you please put it in the chat, and I'll be sure to read it to the board. Thank you. T. Jones is the next one.
I have nothing to add. Thank you.
Thank you. Charlitha Gardner.
Yes, my name is Charlethea Gardner, Tarlethea Gardner, Gardner. I am a resident of Westfield and have been here for 6 years. I have 4 children. I'm a nurse. I'm also a case manager that work with an array of patients. When we met, and I'll be very brief, when we met back in February at the church, as everyone in the community has stated, there was no real treatment plan. There was no real care plan for these patients. And that's a concern of mine as well. I have 2 kids that went to Hamilton that walked by that area, 2 young boys every single day. And children are very impressionable when it comes to certain situations in their surroundings. I also moved from Federal Street, where Turning Point Clinic was located, on the corner of Milton. And I seen the change in the community when the clinic opened up, when the patients were coming through and then put back out in the street, and it was very disturbing. So I just asked the board, send it to the council, and that they really take a look at all the facts and how it affects not just the patients, but the community as a whole. Thank you.
Ma'am, before you go, let me ask one question. Turning Point, was that a facility that's similar to what is being described here?
Well, my understanding is that this facility is supposed to be an inpatient facility, but if they turn it into a methadone clinic, then yes, it would be just like Turning Point, which is a methadone clinic.
Okay, very well. Thank you.
Thomas Marston.
I am good, thank you.
Vicki Johnson.
I'm still here.
Okay, Ms. Johnson, do you wish to speak?
Yeah.
Zoe Bryant. Okay. All right, we have a few more in the chat that also wish to speak. I have a Karen Shelley and Mr. Pellegrini also wishes to speak, but I still have to get through the call-in users. All right, we'll start with Ms. Shelley. Ms. Shelley? Karen? We cannot seem to hear you. If you would like to put what you'd like to say in the chat, that we can see it, I can read it to the board. I'll try to come back to you. I'm going to go to the call-in users, and then Mr. Pellegrini, I'll come to you. I'm going to unmute you in order. If you're a call-in user, hear 2 beeps and you wish to speak, go ahead and speak. Do you wish to speak?
Charles Maloney. Malonee. First name, Charles.
Mr. Mallory, are you here for this one in particular on Harford Road, or are you here for the property on Green Spring?
I'm here for Green Spring. I'm sorry. This is Green Spring, but you.
Mr. Mallory, that hearing concluded. You were not on the line at that time.
Who won?
Well, it's not over yet. You can listen to the board's deliberations at the end, sir.
Thank you.
Thank you. Next caller.
So that's an interesting echo.
All right. Do you wish to speak?
One more, so Brian wants to speak.
Okay. Hearing nothing. And I have to get back to Zoe Bryant too. I guess she didn't connect when I had her on the last time, so we'll get through these calls. Hello, do you wish to speak? No. Hello, do you wish to speak? No. Hello, do you wish to speak? Okay. Hello, do you wish to speak? All right, so I'm going to get back to Miss Bryant. Ms. Shelley has put in the chat that she's having sound issues. She's lived in Westfield for almost 3 years, moved here from Hamden because the center moved in and affected the neighborhood in a negative way. She has major concerns with how it will affect schools and houses around the facility and traffic. And CMDS is not a reputable clinic. They have destroyed neighborhoods around Turning Point. I do not want to be forever out of Westfield due to a center not being holistic. And Ms. Daphne also is having issues with her audio, but let me jump down to Miss Zoe Bryant. Ms. Bryant?
Mr. Bryant, I just have
Mr.
one.
Bryant.
That's okay, that's fine. Just have one quick question for the appellant. I'd like to know, as part of the process, has there been any formal comment from any representative of the Baltimore City Police Department regarding this site? Or has one been solicited? And I ask that given the heightened level of police activity that often occurs in close proximity to these types of centers. Unfortunately, they do become magnets for increased drug activity, but I think it would be ideal to know where the Baltimore City Police Department stands with regards to the proposal for this building. Thank you.
Thank you, sir.
Katie, you're muted.
Katie.
Dang it. I'm trying not to make any extra feedback, so I keep muting and unmuting myself. I do apologize. I'm going to see if Miss Daphne, if you could please go ahead and put your message in the chat. I'll try you one more time. If not, we'll go ahead and go with it from the chat. Yeah, Ms. Daphne, I'm unable to unmute you, so I think you have a connection issue. I believe that we have gone through all of the callers, the call-in, and so Mr. Pellegrini is the last one who wishes to speak. Mr. Pellegrini?
Yeah, can you hear me?
Yeah, sir, if you could speak up, that'd be helpful. Thank you.
Can you hear me?
Yes.
Yeah. Hi, good afternoon. I'm the VP of Finance and Business Development at CMDS. And I think I just want to clarify a few things that the community associations misrepresented. And I think the very first thing that I want to talk about is why we don't want to be an outpatient program. We just don't want to be an outpatient program. The community associations come to the facility, they saw all these beds, they saw that the place is set up to be a residential program. Why would we have invested so much money in buying beds and making the place an inpatient facility when we want to be an outpatient facility? We do not want to be an outpatient facility, although, as mentioned earlier, we have this use by right. So if we wanted to, we could be a methadone program, but that's not our intention. Somebody mentioned about quality of treatment plan. I wonder why they're saying this. We never admitted a patient. How they can say anything about quality of care? We can open our doors. This makes no sense. Also, Ms. Rochelle said something about us not having any criteria to admit patients. Ms. Rochelle worked in this for 40 years, and she doesn't know that every program needs to have some sort of admission criteria to admit patients with a substance use disorder. This shows how much she doesn't know about her own line of work. And also a very important distinction about 30 and CMDS. CMDS does not manage any aspect of clinical or medical care of Turning Point Clinic. CMDS solely administers finance, HR, and IT matters for Turning Point. I just wanted to make that clear. Thank you.
Who did he represent?
I'm the VP of Finance and Business Development for CMDS.
Thank you.
Thank you, sir.
Okay, I believe that is it for testimony. And so I guess it's back to the applicant.
Yeah, Mr. Williams, back to you. Obviously, it's been a lot all day, so we'll hear from you.
Yes, please. I have the ball back, Ms. Byrne.
Yes. There you go, Mr. Williams.
Thank you. I guess, yeah, just to rebut, and I guess Mr. Pellegrini was remote, so I'm sorry that he came in kind of a rebuttal to take more time. I guess just to further clarify the question that was asked of me is that why I want to be an outpatient facility or what comfort the board or community has is that they spend $4 million on a facility and there's building plans prepared for this facility, not built for a outpatient facility. And I guess on the lines of like issues that the community raised, and like Ms. Rollins Green noted that there's a number in the community, but they don't know they exist. And that's basically our point here is that based on the characteristics of this facility, people won't know this place exists either. And there will be no worse impact here than elsewhere in the C2 zoning district. The quality of care concerns are properly raised to MDH or the accrediting body. The bigger point, I guess this is more to address Mr. Murphy's issue about my reliance on the zoning letter, is that the zoning letter was referenced just as, I guess, kind of Mr. Fields. I mean, yeah, sorry about that. So yeah, the bigger point is that the zoning letter was just referenced as part of our argument for reliance and equitable estoppel. A broader point is that the letter doesn't really matter for our legal argument. And then per Mr. Murphy, that we're in democracy, that part of the democracy also protects the tyranny of the majority and protects due process rights. And our argument is simply, in 2017, the board approved the use 38 resident assisted living facility. And the planning staff noted this would be under the new code, licensed residential care facility with 17 or more persons. The use was exercised within 12 months by issuance of the building permit under the code and precedent. Exercising the use is just issuance of the permit. And again, so there's this case law about filing for a permit application counts as exercising a use. But again, here at 6040 Hartford Road, a building permit was actually issued following BMZ Appeal 2017-198 with renovations occurring. And that issuance of the building permit also created a vested property right. And so that the zoning letter, or that the community has testimony evidence that the nursing home use shut down in 2013 may be true, but we have a vested property right was created in 2017 when the building permit was issued. There was no appeal, as Mr. Murphy noted, of the 2017 zoning case. That was the opportunity to raise the issue that the nursing home convalescent facility use had ceased there. In 2017, the BMZ approved this use. It was vested by the issuance of a permit. And now we're proceeding under that permit within the time period. There's been a permit that's been active most of the time, and never been more than multiple months period, nowhere near a 2-year period that would be necessary to consider it a discontinuance or abandonment. I guess the last point is that Mr. Murphy was arguing is that it's a change of use from the 38-bed assisted living facility to now what is proposed to be a 136-bed residential care facility. I mean, so if we accept that their 38-bed facility for assisted living under the current code is a 38-bed residential care facility, that gets us to this point where now we're talking about intensification versus change. And the case law is very supportive of this argument and coming right on point. This case from, we cited the 2006 case, which referenced the Municipal Stadium on 33rd Street, is right on point. There, it was frequently used for football games, track meets, the laser pointer. Football games, track meets, civic events. But then the use was intensified to include baseball games with speakers and lights. And that was considered intensification of that use. Here, we're intensifying the use, but it's allowed by right. And this is the same thing that happened at M&T Bank Stadium. If the Ravens can increase their capacity for the suite, the capacity of the residential care facility can be expanded. I know there are issues that the community has raised about treatment facilities generally and how to handle it as a citywide and really regional issue. And there should be hearings on those things, but the decision for the board, we believe, is simple and isolated simply to this legal question of, can we do this use without any approval? And the facts and case law say we can. So thank you for your time.
Thank you, Mr. Williams. Appreciate your presentation.
Thank you.
Okay, that will conclude the matters for this docket today. The board will proceed to the deliberation portion of the hearing and we'll move forward.